Good morning, good morning, good morning, amazing Law Nerd. It's good to see you. Replay crew, it's good to see you too. If it's good evening, good night, good whatever day you're watching this. But today, it's Tuesday, it's October 28th. We have a lot to talk about, Law Nerds. There is much to discuss. Yes, there is. I have been trying to keep streams to one topic. I have been doing badly at that. I have been trying. I hope you all had a good week. I missed you last week. I was doing all of the parent things. It's Bandtober. We had senior night and band comps, and Octo and Chris were in town, and we were doing Team Baker things and planning things for next year. We were doing all the things, and I cannot wait. The problem with planning in advance with ADHD is that I'm really excited about it right now. And then I am ready to do all the things. And then they take time. And then I'm like, wah. I want to think of the thing and then do it immediately. Having to wait is so hard. It's so hard. But we had lovely Tennessee weather while friends were visiting. So they got to experience oh my God, in the sun, it's summer. And in the not sun, it's fall. And then when the sun goes down, it's winter. So we had a lovely time cruising around all of the things. Our band is doing well. Senior night was good. You know, Travis got honored and all of the things. It was fun. I have updates for the members. I have pictures to share. I have realized more and more when I am in person. I forgot to put my AirPods back. That's what was clicking. I was like, I must do it now or I will forget yet again. I realize that when I am in person more and more, I am not on my phone at all. Like, I'm just not on my phone at all. I am sometimes taking pictures, sometimes forgetting. So I'm going to share those things. It's just going to be a little bit of time. So we have much to talk about today. As I have said today, we need to talk about Trooper Proctor. There's more information. There's more. There's more. And I would say I didn't expect this, but I kind of did. I'm just surprised we're seeing it. Like, I'm surprised we know about it. I'm not surprised that we see it. We're gonna do it. KCMH48 said, I'm about to board to go to Nashville airport for a layover. Got a notification that my Law Nerd merch was delivered back home. That's exciting. There's a Voodoo Donuts in that airport. There is a Starbucks that will let you pre-order. So mobile order if you need Starbucks. There is some very good food in the Nashville airport. And if you're a Delta Lounge kind of a traveler, the lounge there is very nice. It's not the EDB Air Lounge, but it's so much easier when we get to just make it up in our heads than when you actually have to execute it. So we're going to talk about Trooper Proctor, and then we have a bunch of Kouri Richins stuff. Absolutely. Mobile order at Starbucks is a game changer at the airport, and sometimes you can't. Mango Jelly, it's been a minute because I get obsessed with a certain lippy and then I just wear it all the time. I know, I went back to one that I used to wear a bit ago and it just felt like the day because I have like my little like vampire teeth with like a dangly bit on the ears, which is typical because I have so many piercings. I was like, oh, I wanted to do that, but I have so many piercings they can't like sit flat. I have my Twilight tee. I'm themed. It's hua hua season. Brian was like, what are we talking about? Because Travis came home yesterday and was complaining that there is starting to be Christmas music. And he's like, fall needs a moment. I'm like, fall does need a moment. We're going to push back. Fall needs a moment. And that's what we're doing this week. Laura said, I had an EDB moment where someone grabbed the order since we had the same name at Starbucks the other day. Right? In the mobile app, you can change your name so that it's easier to find. I had to do that. So Lots of Kouri Richins stuff, some Proctor stuff, and we're going to talk about it. We have the stuff today. It is so much. It is so much. Also, for those of you that are hunkering down for Hurricane, I have seen that Ryan Hall, y'all, has been live. Stay safe. I know there is not much you can do on an island in the path, but be safe. Take care. I hope you are all well. Also, if I say this all the time, if Ryan Hall, y'all, is live and talking about where you live, go watch him. Come watch me later. I'll be back. Look, it is more important. Weather in your area, like dynamic weather, dangerous weather in your area is more important. I love what we do. I think what we do is incredibly important. It's not as time sensitive. It's just not. I love you. Be safe first. This will be here. I love watching with you live. It is the greatest. But be safe. It will be okay. You can come back. It's going to be here. So I saw yesterday that Ryan Hall, and I was like, oh my. So stay safe. You guys, it is, again, weather is tough. So, all right. We are going to get into the Proctor stuff first. Then we are Peachy Keen. I know this is why I say it. Peachy Keen said, I got to go be safe. Yes. I always want to remind you that, again, it is okay. It is okay. We have replay crew. It will be timestamped. We will have case briefs and the Emily show on the other channel. So if you need to just tune back in on the other channel to get the quick of what's going on, we do it so that when you want to watch, you can. And when you can't watch, you can stay in the loop, because life gets in the way. Life gets busy and complicated, and sometimes you just need to stay safe. So that is why we do all of the things that we do. So Time said, weren't there any updates on Ron? We did those last week. There are none since last week. We did. It is timestamped. So last Tuesday, we updated. For all of you that got your Lawnerd merch, I'm so glad. That you did. Are we ready to talk about Trooper Proctor? Are we sick of Trooper Proctor yet? I mean, yes and no, and yes. We will talk about Spidey D being thirst trapped in the bookcases. Probably more tomorrow. We will talk about it. Don't worry. So for those of you that got your EDB Air merch, I'm so glad you are enjoying it. We still have just a few things left. We will have more merch for you. We have been working very hard to have more merch for you and to restock some of the things that you have been asking for next month. So, baby steps. Don't say it out loud, because there will be fires again. And he has in the past talked about fires. We will probably talk about the Palisades fire prosecution next month. I don't think we're going to get to it this month. I'm just thinking about what we have on the docket this month. I don't think we're going to get to it. Probably next month. And I know we're tired of Trooper Proctor, but also when there's more, it's just like, well, we're covering the hearing on Thursday. We're covering the hearing on the 30th. That's Thursday. So we're going to cover the hearing on the 30th. So we might as well just cover this stuff now. And then we are definitely going to do food court this week. We're going to do food court tomorrow. I decided that we will cover the hearing live because we're all curious, and then we will see how long or not long the hearing is. And we'll cover that on Thursday. So that will be Thursday, food court Wednesday, today, Trooper Proctor. Today, Trooper Proctor. And then lots and lots of Kouri Richins. So for those of you all like, what hearing? There is a continued hearing with regard to Trooper Proctor's phone discovery and the Proctor log. We'll do it when we do a summary. So we're going to cover that hearing live on Thursday. So we should just roll the intro We should get to Proctor. We should do all of the thing. I see all of you asking about Jackson's letter about Commissioner Cox. We have so much Richins stuff today. We might talk about it Thursday, but I'm waiting for responses and then we can group it together because there is so much new Richins stuff that we have not talked about yet. I mean, I guess I'm not really shooketh by Jackson being like, hey, he knew. We knew that. Like, we knew that. We knew that. Helena in the chat said, EB, you got me so hooked on Midas Merge. I don't even want to go to bed ever now. I'm playing right now. This is how y'all are higher levels than me and Midas Merge because you play while streaming. It's the perfect thing to play while streaming or watching TV or what have you. I had to put a timer on it at night. I had to put a timer on it at night. That is my secret. So I set aside unabashed time and then I put a timer on it. That's me, 100%. So let's go live and then, well, no, we're already live. Emily, you didn't stream for like 2 days and now you're ridiculous. Let's roll the intro. We got to talk about the Proctor problems first because these text messages, oh boy.
The law, the strategy, and the evidence in real time, so you know what's happening.
That was 100% me.
So
that was
join the
100%
Lonards in
me,
the
you
chat.
guys.
They're here for the facts, not and let's get to court.
That was 100% me. If you didn't hear that, if you heard it, great. If you didn't, that was 100% me. Here's the thing. My computer had a whole situation. And so I had to like restart everything. And then apparently it just didn't want to play the audio because it was me. Well, it played the audio. It wasn't connected to the... It's just me. It's just me. I'm the problem. It's me. Let's do a quick road so far of WTF is going on with Trooper Proctor and catching up from last week for those of you that are like, what is happening? And then we'll get into the details that we have ahead of the hearing on Thursday. Look, y'all have followed along long enough to know that Trooper Proctor was put on administrative leave. Then they went through the entire board, the trial board, through the law enforcement civil service process to decide what discipline, if any, what if any discipline would befall Trooper Proctor. And then he was terminated. And then he appealed it to the appeals board and said, this is a very brief summary, but if you want to know about what now former Trooper Proctor's lawyer said, I did an entire case brief on it where I broke down the opening statements from the Civil Service Commission appeal. So if you would like to hear more about that, I have an entire, it might have actually been a podcast episode on the Emily Show. That's on a separate channel. We'll link it down below if you want to see how his attorney argued it. This is the EDB summary. You guys, other officers text message, they didn't get fired. Y'all just fired him because people are mad on Twitter. That's like totally unfair and it's not equitable. So he like totally shouldn't be fired because other people weren't fired. And we're trying to like argue to fight for his rights. And you didn't give us the discovery. Massachusetts State Police didn't give us the discovery. So we need another month until we get our discovery, because how can you even argue anything? How can you defend your rights without the discovery? Fair point. But also, so sad. So that is my summary of the argument at the appeal board. And then they did the first days of hearing at the appeal board and said, essentially, this is why he was fired, and this is how it was decided that he was fired. And oh look, not only is this why he was fired, but these are the things he said in his 2020 interview. Katie in the chat said, can't they fight for his right to party? No, Katie, they can only fight for his right to pity party. I don't know where my rim shot is in my soundboard anymore, but just that's where it goes. It goes right there. That's it. It goes right there.
That's suspicious. That's weird.
So, Trooper Proctor puts over, they do the first couple days, the state presents their case. Well, the state police, MSP, presents their case. Hey, this is why he was fired. And then they put it over more than a month. Well, no, it was like 3 months to have the defense present their case. And they had set aside 3 days. And then he stunningly withdrew his appeal. Just gone. And then his attorney withdrew from the other cases. And we were talking about it, and Chad is Bay and was like, hey, that's his attorney from the police union. And this is not unusual. I mean, if you look at police unions, teachers unions, and other large unions, the union provides you counsel and pays for it and takes care of it when it is within your job functions. So the he withdrew his case, and then the police union attorney withdrew from all the other things. And we were talking about which came first, chicken or the egg, a little bit. And we didn't have a ton of information on that. Did he withdraw his appeal because of the discovery of his iCloud that it seems that, watch last week, he thought was gone, wasn't gone? And we suspected the timing was like, yes. That discovery, maybe he and his lawyer had a heart-to-heart and were like, there's nowhere we can go with this. That's not exactly what happened, and now we know. The Boston Globe has a statement from state police letting us know that it didn't go down quite the way that we suspected it did. Similar, but don't we love the more details? Don't we? I do too. I love the more details. So let's pull up this article from the Boston Globe and take a look at what we know, because now we know more. Oh, it just doesn't want to move the way I want it to move. Let's see if we do it. Nope, that's worse. The websites they fight with me and then I fight with them. They're like, Emily, you can't get rid of our ads. The headline is a little cut off. Apologies to the author, Travis Anderson. Another Mr. Anderson, just spelled differently. State Police Union pulled support for former Trooper Michael Proctor prior to appeal drop. Whoomp, there it is. This just does not want to play nicely the way that all the other websites we pull up are formatted so that this is easier. Fuck it, you're going to reader mode. You saw his face. You know what he looks like. They know, we all know. The Union for the State Police Troopers pulled its support for former Trooper Michael Proctor's appeal of his firing shortly before he dropped it last week. They pulled out before he withdrew. Emily, it's not an After Dark episode. It's going to be fine. Quote, following the discovery of new evidence from Michael Proctor's cell phone, the State Police Association of Massachusetts Executive Board unanimously voted to sever all support from his appeal. Brian Williams, the union president, said in a statement, "We hope this decisive move closes a deeply embarrassing chapter in state police history." Chat, does this close the chapter? I don't think I've ever seen a union do this and B, make a statement that they did it. They're like, we might not drive the bus, but we're riding shotgun and we're throwing you immediately under it. Immediately under it. But is this over? No. I think it's way too late. Gold Dragonette said a union dropping you needs something really serious. Yeah. Aaron in the chat, accurate as always, said so strong pullout game. Yeah, from the union. 100%. Scorpion, also, yes, I see what you did there. We're trying to rein it in, but not really. Scorpion said, Emily, could Proctor have decided to hire his own lawyer and go on with his appeal? He could have. He could have chosen to do that. But without the support of the union, the Civil Service Board is going to look at the union and state police and say, everyone thinks you should be fired. Why would we override that? So yes, in theory, he could. He can't now. He can't change his mind now. It's too late. So oh yes, we talked about this last time. Diaz Ditos Down said spam noped out. Yes. The State Police Association, Massachusetts. Yes. SPAM. Yeah. Spam was like, no, we don't want to be fried. We know you're cooked. We would like to not be cooked. We would like to not be deep fried with you. Yes. You're cooked. We're out. So once the union noped out, the union lawyer noped out, and that had to have been on like Friday when he signed that he was also withdrawing his appeal. Because when you don't have the union support, there's no way his appeal is going to go anywhere. Absolutely cooked. But the union for state police pulled their support in a unanimous vote. They say, we hope this decisive move closes a deeply embarrassing chapter. Dude, I have a feeling that this isn't a chapter. We're in book 1. We're in a chapter of book 1. We're not even close to done. Because who else are you texting? I want to see who decides to retire, who leaves. I have so many questions, but this isn't going to close the chapter. They are going to have to do, there is going to be more. Remember, the reason that disciplinary action was taken against whichever Albert works at Canton PD. Kevin, is it Kevin? Kevin Albert is only because of text messages between him and Proctor. That's the only reason he was disciplined. That's not going to be the only thing that they find in this phone. So, also for everyone who's all of a sudden getting new phones, they already have it. So, good luck. The Globe goes on to say Proctor, the lead investigator. Yes, I'm glad we can now all agree on that point. The lead investigator in the Karen Reed case was fired in March after he was forced during her first trial last year to read aloud vulgar and misogynistic text he'd sent about her to friends and coworkers. We know that Reed's trial ended with a hung jury, and then she was acquitted of everything except a driving under the influence. After Proctor's texts came to light, defense lawyers in other murder cases he investigated began seeking access to his devices for evidence of possible bias in other matters. Ding, 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 ding. That's what we're still talking about. That's why we're still talking about this. Proctor's lawyer, Daniel Moynihan, said in a brief statement on Monday that his client's appeal to the state's Civil Service Commission was withdrawn on Friday upon, quote, disclosures made available to our office. He did not elaborate. Did they give you all the texts? Did you just like control F your way through them to see how bad they were? Or like, how did that go? He did not elaborate. Attorney-client privilege is a thing. At the time of Proctor's firing, Moynihan had said that his client, quote, never denied that he sent derogatory and vulgar text messages in private conversations with personal friends. Moynihan said, adding that Proctor, quote, does deny that his investigation in this case was compromised in any way. You know what? Here's the thing. I don't know if I'm starting to believe him a little bit. Hear me out. Hear me out. What we read last week was that Proctor's lawyer said, oh, there's probably not going to be any like cell phone information to discover because everything deletes every 30 days and he got a new phone and blah, 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 blah. And then all of it was still there in his iCloud. It goes back to how incompetent is it all just incompetent? He's like, I'm not biased. I'm not even able to be biased. Because he just doesn't know what the fuck I don't know. Do I think that's 100% true? The benefit of the doubt is he really is that incompetent. In addition to being all of the other things, including biased. Because going into an investigation with an outcome predetermined is a biased investigation. You can't say, oh, it must have been that. Let's go prove that it's that. Okay. But also, I think we got a lot of questions about competence. Because you know he wanted those messages to be gone. You know he wanted the iCloud to be gone. Or is this so prevalent and commonplace that he really thinks it's no big deal? So he's like, no, my investigation wasn't biased. You decide who did it, and then you go prove who did it. Sir, that's not how that works. But I think he thinks that that's how it works. So he's just like, this is what we're doing. What's the big deal? So what if I don't like the defendant and call her all the nasty words and hope that she, harms herself so that this doesn't go to trial? So what? Yeah, this is not closing a chapter. This is a huge problem. So he said that his investigation wasn't compromised. And I think that Proctor believes that. I think that Proctor believes it wasn't compromised because that's how he always does it. 100%. But that doesn't mean it's right. We always do it that way. That doesn't mean it's the right way. Ronna Cooley in the chat said this is the opening. This is opening the big book. Mm-hmm. In court papers last week, and again, this article was written in the middle of last week when EDB was off. In court papers last week, prosecutors, so this is 2 weeks ago now, prosecutors said they're reviewing material from Proctor's personal cell phone for information reasonably believed to be part of discovery and other pending murder cases, the Walsh case, the King case, and others. Quote, this is just delicious, so I'm reading it again. Quote, due to the unexpected volume of files discovered on the cell phone, review of the extraction is not yet complete. The extraction has yielded hundreds of thousands of items, some of which are dated back as far as 2013. Prosecutor said that the volume of items was unexpectedly larger than the representations of Proctor's counsel regarding the cell phone. Right, because they said, but he got a new phone. There's nothing. Wrong. XO Ebby said the only person allowed to say this is how we do it is Montel Jordan. 100%. This is how we do it. It's 95. Emily, stop. This is how we do it. It's a great song. So yeah. Unexpected volumes of discovery. Proctor was the lead state police investigator in the case of Brian Walsh, a Cohasset man who allegedly killed and dismembered his wife. Lawyers for Walsh, who's held without bail on murder and other charges, has been granted access to Proctor's federal grand jury testimony related to the Reed case as they prepare for trial. The Justice Department had convened a federal grand jury to look into state law enforcement's handling of the Reed case. That I maintain still is a bit speculative, but it's also the only thing that makes sense. No one's been charged with any federal crimes directly related to O'Keefe's death, but a woman who heard evidence on the federal grand jury pleaded guilty in August to leaking the information. Right. A grand juror pled to more serious crimes than Karen Reed was convicted of. That's true. In Walsh's case, a judge said the federal grand jury records shall be limited to the defendant's counsel of record in the above captioned case and in a direct appeal, if any, of the above captioned case. But that's not the end. That's not the end. Because it's not just the Walsh case. It's the Walsh case. It's the King case. The Walsh case still has quite a lot going on. The trial date has been pushed. I think it's going to continue to get pushed. I don't think it's going to go to trial next month. I've been surprised before, but with how much keeps bubbling up about Proctor, it's, I'm sure, frustrating for Walsh's attorney, but this was going on. You need to know what's in Proctor's phone if he's talking about your client too. All of the defense attorneys at this point have to be like, we need to know what else is there. So last week, when we took a look at the court hearing with regard to this, they were still trying to figure out what was being turned over in the federal grand jury, because prosecutors said, we can turn over this information that we were given permission to turn over. This is all that we asked for. We don't think all of it's exculpatory. And the defense is like, how can we object that there's more that we need to see if we don't even know what it is? And the prosecutor said, well, we'll give you the log from the federal grand jury. And so they will be back in court this week to talk about that. But there is still this ongoing issue of what is in Proctor's personal phone and what will prosecutors determine needs to be turned over. If I was a prosecutor in this case, and I'd be curious what other prosecutors think about this, but if I was the prosecutor in that case, my nose is going to itch. We need a Kleenex. If I was a prosecutor in that case, given the volume of discovery, I think I would also want, someone else to look at it to determine the exculpatory nature of it. So I think I would want the court to appoint a discovery referee or whatever they call them in Massachusetts. I would want to turn over the volume of everything to someone and be like, can you also look at it? Because A, it's a lot, and B, I'm all in the turnover more. Because though something might not be directly related to like the Walsh case, bias and behavior in other cases can come up. So SK Dewitt said in Massachusetts, it's a discovery pilgrim. Special master, yes, probably a special master. Discovery referee, special master, taint attorney. Well, they might need a taint attorney too, but they need someone, I think, outside of the DA's office at this point to look at it. And I hope that they do that. I don't think that they will, but I hope that they will, because I think it would help. So Friday, there were new filings in the connected cases we looked at filings from the Walsh case. The filing that we're pulling up now is from the Myles King case. We have not gone over those cases other than the discovery fights. The Myles King case is the case where Lally was on the stand talking about, well, I asked for the discovery and Proctor didn't give it to me. And the defense is like, and then? He's like, well, and then nothing. And then I nothing it. Like, and then nothing. Okay. That case. Emo Lawn Flamingo said, please tell me someone has the actual title of taint attorney. Yes. The attorney who looks to see if it can be turned over, if it's tainted, not tainted, if it's privileged, not privileged. So there are numerous logs that are going to be involved, including privilege logs. But this was shared by Ted Daniel over on the Bird app, which again is what it is. I go so you don't have to. I'll bring you what you need to know, and then we'll get out. But we also have a article written by him. So if you want to go look at the article, you can. So let's see. Some of you are saying that you are having some stream issues. I do not see those on my end because the stream health on my end is showing excellent. So refresh on the YouTube end. I apologize, but that is a YouTube issue. So the stream health on our end is excellent. On your end, it is probably a YouTube restart the app or open a new window. Let's take a look at what was filed in the Myles King case on Friday last week. So that would have been, the 24th? Because, oh boy, we learned some new information. Should we fly to Massachusetts? Should we? I feel like we should. We're going to have to fly to Utah. Maybe we just wait and fly to Utah. We'll wait and fly to Utah. We'll swoop to this new filing. It needs its own moment. That was me. All right, that's better. It needs its own moment. So if the text looks a little blurry to you, again, motions in Massachusetts are difficult. They are difficult. So it is what it is. Commonwealth versus Myles King. The Commonwealth's motion for protective order regarding information derived from review of extraction of a former, they don't even name him, of a former Massachusetts State Police trooper's personal phone. We all know who you're talking about. We all know. We all know. The Commonwealth moves pursuant to Massachusetts Rule of Criminal Procedure 14.2G. Remember, Rule 14 is the discovery section. That dissemination of materials from an extraction of former state police trooper Michael Proctor's personal cell phone be restricted. Grounds. On June 17th, 2025, this court, in specific cases, footnote 1, it lists all the associated cases, including King and Cisnero, Sinchero, De Los Santos, and others. In specific cases, allowed in part defense motions for discovery of former Trooper Proctor's personal cell phone. The order included that order included that the Commonwealth produce communications from the dates of the charged offenses to the dates that indictments issued and produce any other data from Proctor's personal cell that constitutes investigative materials or is favorable to the defense within the meaning of Rule 14. The Myles King case goes back like 5 years. Mostly because of like Mass State Police and prosecutor delay. But it opens up a treasure trove of phone because of how old the case is. So that's the court's order. The court further ordered that the Commonwealth may move for appropriate protective orders for the court's review prior to producing the items or information, and that, quote, defense counsel shall not show or provide the communications produced pursuant to this order to anyone else if these things leak into the media, the court's going to be fucking pissed. To anyone else except that defense counsel may show but not give them to the defendants in this case. So they may talk to their clients about it. They may show their clients, but they cannot give their clients digital copies, physical copies, anything like that. Upon filing of a motion and amended motion for clarification by former Trooper Proctor's counsel on August 13th, the court clarified that, quote, the obligation to produce any other data that constitutes investigative materials or is favorable to the defense is not limited to a particular date range. So the court said you need to turn over materials from the date of the crime through the indictment plus any of this. The plus any of this is not limited. And that former trooper had a legitimate interest in protecting attorney-client or spousal communications. Remember, that's going to exclude things like group texts. And we know he's fond of a group text. We've seen those texts from the feds. It goes on to say that the court issued further, that was an awkward lead into a sentence, but it is what it is. The motion goes on to say the court issued further orders about discovery and extraction of the phone, the opportunity for the former trooper's counsel to submit a privilege log. That's one of the logs we're going to be talking about. And a timeline for the Commonwealth to produce discoverable materials. So the defense attorneys are asked to go to the prosecutor and say, hey, oh no, that's the timeline that the judge gave the prosecution. But Trooper Proctor's lawyer is, at the time, because he's now withdrawn, but was able to go to the prosecution and said, this phone number is wife, this phone number is lawyer, so these communications between this number and this number should be privileged and should be excluded. And then said that the Commonwealth had a certain amount of time to turn these things over. That's footnote 2. Footnote 2 lists the cases again. Under Massachusetts law, all items and information favorable to the defendant within the possession, custody, or control of the prosecutor, prosecuting office, or prosecution team must be disclosed. I think you just give more and then ask the court to keep it out of trial. I think you over-deliver in this circumstance or have someone else review it. The prosecution goes on to say, review of the personal cell phone is ongoing. At this time, pursuant to Rule 14, the Commonwealth is producing text chats, audio files, and video files, which span many years. One text chat contains highly sensitive information, including images of intimate body parts of people not participating in the chat. Screenshots of Facebook posts by non-participants, images of non-participants, full phone numbers and personal email addresses of the text chain participants, and the name of a sexual assault victim. Let's just go over that one more time. This is his personal phone. In his personal phone, it says in one text chat, there is highly sensitive information, including images of intimate body parts of people not participating in the chat. I have seen much speculation in my DMs. Are those Trooper Proctor pics? No. Because if Trooper Proctor wasn't participating in the chat, then it wouldn't be on his phone. People not participating in the chat. Awkward Cali Girl said, can we please call him names? Just not in chat. I hear you, but names, just names, all the names. So those are not based on the way this is written, Proctor images. I worry deeply about where those images comes from. I worry about where those images are coming from. Being shared on his personal phone. I'm less horrified if they are screenshots from the Bird app of like, you're not going to believe this. Less concerned. I am gravely and deeply concerned that is not what this is. That is not what is meant by this. I am deeply concerned that is not what is meant. I am concerned. I am concerned. So, they are not his images. They are someone's body parts. We do not know who. We also do not know if he is the one sending those photos or if someone else in the chat is sending those photos. We do not know that. Assumptions can be made, but we do not know. So, there are sensitive images, screenshots of Facebook posts by non-participants. Who are they talking about? Who are they talking about? And who is posting what on Facebook? And images of non-participants. Who are the images of? Who are they talking about? Are they talking about defendants? Are they talking about witnesses? Are they talking about lawyers? Because we saw that they were talking about David Yannetti like a freaking, everything but a child of God. Who are they talking about? Full phone numbers and emails of the text chain participants. I mean, you need those to identify individuals, but they can be redacted fine. And the name of a victim, which again, shouldn't be disclosed on a personal phone in a chat. Shouldn't be disclosed. So I wonder what else he shared. It's concerning. It's really, really concerning. And he's already fired. To anyone on a group chat with Trooper Proctor, I hope you're sleeping the way that you should be after knowing all of this. Because it's going to be really weird when all of y'all's jobs find out about all of this. So, yeah. You're going to have the experience that's coming to you with that. Don't do that. Don't do that. They go on to say under Massachusetts Rule of Criminal Procedure 14.2G, quote, upon a sufficient showing, a judge may at any time order that the discovery or inspection be denied, restricted, or deferred, or make such other order as is appropriate. The judge may alter the time requirements. The judge may, for cause shown, grant discovery to a defendant on the condition that the material to be discovered is available only to counsel. I think that's appropriate. I think it's appropriate to make sure there's a protective order here so that what is being shared and those that, because it sounds like everything being shared that they're talking about is not from participants within the chat, that those individuals are protected. So I agree that there should be protection on that. It goes on to say the issuance of a protective order is the inherent authority of the issuing court, and, quote, protective orders serve to shield litigants and third parties from unwarranted disclosures It doesn't help all the people who Proctor's disclosing stuff about, but he will get the benefit of this. Those in cases that he was working didn't get that benefit, but he will get that benefit. The prosecutor in the motion for protective order goes on to say non-parties have a privacy interest in not having their images, their complete cell phone numbers, or email numbers publicly displayed. Names of sexual assault victims in court records or police reports may not be disseminated except with the consent of a justice of such court where the complaint or indictment is or would be prosecuted and are otherwise withheld from public inspection, except apparently in Trooper Proctor's group text. The court system goes a long way to try to redact those names, except apparently in group texts, because Trooper Proctor doesn't seem to give a fuck. It goes on to say, further, non-participants who appear within the produced materials may have a security interest in not having their personal identifying information released to protect against harassment. Right. Why was Proctor or his group text sharing the things, though? Why were they sharing the things? What were they sharing? They go on to cite, in parentheses, while the Commonwealth bears the burden of demonstrating risk of safety, it need not demonstrate a specific or actual threat where danger to witness safety is inherent in situation. I think they're missing a word. Goes on to say, further, where such information was provided upon a court order in specific cases and dissemination was subject to restrictions as a condition of its release, the court should order similar restrictions prior to the production of the case material. So there's good cause to limit the dissemination to one copy, the further copying be prohibited, and the materials be shown but not provided to the defendant, and the materials are not otherwise disseminated outside the criminal case. The materials will be provided in an electronic format with text chains, including embedded audio files. The voice chats, where the text chains include the name of a sexual assault victim, the Commonwealth requests that it be allowed to omit the electronic version of the messages that include the victim's name from the electronic production so as to redact the victim's name and provide a PDF. I hope that whatever case that is involved in, Victim Witness Services has reached out to said victim to let them know what is happening. I hope that they have done that. I can't say what the Norfolk County DA's office will or won't do. I can't predict it. But I can hope. His fucking personal phone. Like, what are you doing? The courts go so far to try to redact things and protect things and make sure that there are protections while seeking justice. And then he just puts it all in his personal fucking phone. Chat, will you remind me how much the County of Los Angeles paid to Kobe Bryant's widow, because I don't remember off the top of my head. But the difficult thing here is if victims don't know, they can't sue over the violation of their privacy. They should be given the information so they can decide whether to sue. Lauren M. in the chat said almost 30 million. 28.85. Thank you, chat. So I don't think people are going to be suing Proctor. But I think Mass State Police should start budgeting for some lawsuits, which I think would be appropriate. Because I think a jury would be like, all. They can sue Proctor. But I think a jury would just be like, all. Here's all. They go on to say, review of the extraction is ongoing. There may be additional materials that the Commonwealth will provide under Massachusetts Rule of Criminal Procedure 14b2 to streamline future discovery. The Commonwealth request as set forth in the appended proposed protective order that where the Commonwealth believes that there is good cause, future production of materials from extraction be redacted or limited to the defendant's counsel and dissemination of such much materials, more materials, as such much materials be provided outside of the criminal proceeding, limited without prejudice to a motion to modify the protective order by either party on good cause stated footnote 3. I need to try to discern what the handwriting is for the court. I think it says, I have no idea. Something. Counsel. Oh, and her investigator. So it's be redacted or limited to defendant's counsel and her experts and investigator. Thank you. Experts and investigator. So the defense attorney is asking that the defense team be allowed to see these. Footnote 3 says, upon request, the NDAO will make the materials believed to be discoverable to the court for in-camera review. The case it's quoting says, where Commonwealth is in possession of information that may otherwise be subject to discovery, it must file request for protective order and present information for in-camera review. So I think the court should have access to all of it at a minimum. Though I think I'd also want somebody independent of all of this. So this was filed in the Myles King case. There are numerous other cases where there are fights over these downloads. A number of you asked, and it is a great question, a number of you asked, does this negate or moot the fight that is ongoing over the federal discovery? I don't think that it does. Here's why. The federal discovery is extractions maybe from Proctor's phone, maybe from his work phone, maybe from both. We don't quite know. But if I was the defense, I would want to take a look at what is in the downloads from Proctor's discovery from the feds and anything that might have changed in the discovery turned over by the state. So I think the defense needs to still fight for both. And I think that the defense will still fight for both. I mean, they're the defense. They're going to fight for everything. That's what they do. That is their job is to fight for all of the things. So we are now looking at the state, the Commonwealth, requesting a protective order regarding Trooper Proctor's personal phone. Remember, there are two sets of data that we are talking about sometimes simultaneously. There is the federal discovery that was turned over in the Reed case. That is the federal set, and then there is the state set. The state set of discovery is the recently downloaded, discovered Proctor personal phone, well, iCloud, that goes back to like 2013, which seems like it's not that long after maybe iCloud started. But the Proctor personal phone from the Commonwealth goes back to 2013 with hundreds of thousands of everything. The federal discovery is what we saw being discussed last week in a hearing. The federal discovery was part of the grand jury investigation that we heard about in the Reed trial. The federal discovery was part of their investigation, and it was turned over to Karen Reed's defense attorneys and to the Commonwealth prosecutors under a federal protective order that it could only be used for that case. And there has been much fighting going on. There has been much fighting going on over what will be turned over in these other cases because there is a federal protective order. And we talked about the situation where the Commonwealth had information they believed was discoverable and then said, but we're under a federal protective order not to give it to you. And then we got all the way back around to, we asked for the things that we think are discoverable. We've received permission from the feds to turn over what we think is discoverable. And the defense saying, well, how do we know there's not more? And the prosecution said, well, we'll give you the log from the federal grand jury and you can make those arguments. We'll see more of that on Thursday this week on the 30th. But there are two sets of information. The federal set of information, when the feds turned over the discovery to the state, they said, hey, you can only have this for a limited period of time before you have to give it back to the feds or destroy it. So that's why there is discussion of the kind of give back or destroy, not seek and destroy, give back or destroy. But it doesn't mean the feds are getting rid of it. That means the state prosecutors have to hot potato it before that date. But the feds aren't getting rid of it. The feds said, you can't just keep this forever. So there is still back and forth going on over the federal set of discovery, different than the state set of discovery. Lori and CT said, but the destroy date is the 31st. If it doesn't get pushed, it's been pushed. And I imagine the court will issue an order saying, you can't destroy this. And then the court will fight over the feds with the feds order. So you then have a Commonwealth level judge fighting with a federal level judge over what they can do. Ultimately, the defense attorneys are going to have to get the information that they're entitled to. And the feds will still have that information. It will not be gone. PCM asked the question that most of you are thinking, and we've talked about it a couple times. I'm not saying that to dissuade the question. I'm saying that to highlight how prevalent of a question this is and how much consideration there is. Can't the attorneys go to the feds and ask for it? Not really. They can try, but they're not a party to any of the federal cases where the Commonwealth is. So it is harder for the defense attorneys to say, excuse me, we have an interest in this. They don't even go here. They're not a part of that case. The defense attorney in the Walsh case or the Myles King case have no tie to a federal grand jury in the Reed case, but the prosecutors do. And so the prosecutors have an obligation. And I still think if the prosecution's obligation isn't met, it causes some serious implication for those defendants. And what I think the judge is trying to avoid is a situation where the defense attorneys are saying, we know there's discovery. You won't give it to us. You have to dismiss this case. And no one, I think, wants, well, most, I would imagine, don't want the Walsh case or the King case or others to just get thrown out because of this federal discovery. These cases should be tried on their merits, but the defense has to have the discovery to do it. And sometimes when there are discovery violations, the ultimate consequence is, well, then you can't put this case to a jury. And that is the consequence I don't think the court wants to see. But the defense getting answers to the TUI request isn't going to go well because It's federal grand jury materials. They are all sealed. They aren't parties to the case. And the feds have already indicated in other motions that they're disinclined to help at all. Just completely disinclined. So it puts everyone in the state case in a difficult spot. And that's why there's another hearing about it this week. What do we do about the federal discovery? In addition to the treasure trove of Commonwealth level discovery. But if there's different things in the federal discovery than in the state level discovery, the defense attorneys have a right to know what was yeeted. And if the defense attorneys in this case don't have Proctor's work phone, and the federal discovery has Proctor's work phone, they have a right to that too. So I empathize for the defense in this, because they're like, how can we argue what we don't know exists? And my empathy is fairly limited for the state in this. But I get where a prosecutor is sitting there going, so there's a federal protective order and a discovery obligation. And we are stuck in the middle of those two things. And I think the court needs to just say, you can't destroy this until this issue is settled. And then if that means that the prosecutors for the Commonwealth are violating the federal protective order by not destroying it, then they're going to have to go fight it in federal court. And be like, but we have a discovery obligation. So where is the supremacy of those obligations between the federal discovery order and the state level discovery rules? Because you're talking at the end of the day about the defendant's constitutional rights. So if you don't destroy it by the date, what's the federal judge going? I mean, what's going to actually happen? And I'm sure the prosecutors aren't thrilled about finding that out, but it's a real unusual circumstance to be in. I don't know if the feds know how to navigate it either. I don't think you can turn it over in violation of the federal protective order. But if the court orders you to not destroy it, then I think you have to not destroy it. Fucking mess. And at this point, I'm very much pro turn it all over and sort it out. Turn it all over and sort it down. Sort it out. Sort it out later. Sort it out. It won't all come in trial. But at this point, they need to know. Absolute mess. Absolute mess. I can't even, there are so many S's. Autisticus, I think. Are they exercising their right to speedy trial? The speedy trial rights in Massachusetts, from everything I can glean, are kind of a cluster. In one of the cases, the government just made a motion to embiggen time. Yes, that was the actual legal title of the motion. I didn't grab it. In the King case, he was released on bond because of the delays. So he is no longer in custody because of the delays. His is the most delayed. Megan May Lee Plus said, this is a bar exam question from hell. 100%. I do not know the answer. Like, I know the answer. Like, it's a very theoretically nerdy question to be like, what would the law do here? But then, like, what would the prosecutor do here is a difficult question. It's a difficult question because you have a lot of different obligations. And I think all you can do is make sure it doesn't get destroyed and then continue to fight to turn it over. And then you have to do the right thing. I don't know if the DAs trust that their boss will have their back. Because you would hope that the higher ups in the office would be like, hey, we need to protect the rights of the victims and the defendants in our jurisdiction. That is our obligation. That is our obligation. So I don't give a fuck what the feds say. We're not destroying it until the court sorts it out. I'm not confident. I'm not confident that will happen here. So I have concerns. What would I do if I was the judge? I would be more willing as the judge to, I think, fight with the federal judge. Like, what are you going to do? And I think what I would do as the judge is say, I need a copy of all the discovery, and I am holding it essentially in abeyance till this issue is sorted. I am making sure, okay, if your obligation is to turn it over or return it, you're returning it to the court. I am ordering you to give every single copy of the discovery to the court. It is now in my possession and control as the court. And we will figure out what the orders are before it is disclosed to anyone. But prosecution, you have met your obligation. You have returned the discovery by the deadline. Defense, nothing is getting destroyed. I am holding on to it, and we will fight over whose order is correct, because it's also the court's obligation to protect justice in their courts. And then let them fight. So we will see. We will see. Are we ready to move on to Kouri Richins? I start a few questions. Kimberly asked, question, what is an in-camera review? It is not like Zoolander, like the files are in the computer, but kind of. It is the judge reviewing it in chambers in private. So it is in camera Latin. Hold on. Let's go to Black's Law Dictionary. I can't even reach it because oh, wait a second. Hold on. My Black's Law Dictionary is right there. Emily, would it be faster to digitally do it? Yeah. Yeah, it would. Yeah, it would be faster. But it's right here. I can grab it. Barely. We can barely grab it. Don't look at the power strip on the floor. We don't. All right. I know, but book is available. Book also is more dramatic. Books are way more fun. Oh God, I forget how small the font is. I need to go find my other Black's Law Dictionary. This is I got an updated one. I have two. I have the other one much more tabbed. This one is newer. Let's see. The first page I came to is hypothetical. Yes, we know what a hypothetical is. What is going to happen to Proctor? Well, we can speculate. We just won't do it in chat. Let's see. Let's go the direct definition. We're almost there. Let's see. Where is in camera? Has to be here pretty much at the beginning. Let's find it. Inadequate. No, we're cheeky dictionary. No, inadequate's not what we're looking for. It's what we're finding in these cases, but it's not, we're not looking for inadequate. That's not what we're looking. Inadvertent negligence. No. Sassy Black Law Dictionary. No. Not inadvertent negligence. However, it does say see negligence, which, accurate. Accurate. No, not in ambiguo. No. But in ambiguo just means in doubt because it's, ambiguous. We're not there. We're almost to in camera. Hold on. No. In camera inspection. Okay, we've got both. Hold on. We have both. In camera, law Latin. It doesn't even say Latin. It says law Latin. I love the updated version. Law Latin in chamber. Literally in chambers. I always say in chambers because it's called the judge's chambers. It's the literal definition. Sometimes you know things and you forget that you know them. The origin is from 1872. In the judge's private chambers, in the courtroom with all spectators excluded, or taken when court is not in session, also termed in reference to the opinion of one judge in chambers. It's literally the direct translation is in chambers. I knew this. I just forget. So in camera, literally in the judge's chambers, it's for the judge to review without the other parties. So it's literally, let me peep at that. Let me peep it. Let me peep it. So what else? So Kimberly, that is literally the let me peep it by myself. Direct translation in chambers. Why are the judges' chambers called chambers? I don't know. We can explore another day. Heather Ruth, do you have that book memorized? Oh no. Lawyers don't memorize things. We just know where to go look for the information. And then the things I do have memorized, I forget that I have memorized, like that. It literally translates to in chambers. 10 out of 10. 10 out of 10. I knew more of it when I was in law school because I use legal jargon in everyday life much more frequently. Now I use slang legal jargon and then forget that it's actually dead ass accurate. Because I've been doing it this way for so long. Oh. I am DA Crow 76. MDA Crow? I'm DeCrow? We're going with that. You think they thought Karen would not fight? Yeah. Yeah, I think that they had an inkling that perhaps Karen Read would not fight. We saw it in the text messages. Were they Matt McCabe's text messages? Like, if she takes it to trial, it's going to be a whole ordeal. I'm paraphrasing. But yeah, I think they thought she would not fight. Awkward Aquarian, I'm so sorry for your experience. It is unfortunately a growing and more common experience. And this is not something that should ever happen. But it is incredibly violating. And I have deep concerns about what else they're going to find on Proctor's phone and from who. But if it touches into other law enforcement officers, I imagine there will be other investigations. Julie Maud in the chat said grave concerns. I think we've actually found the legitimate grave concerns. I think we have found the legitimate grave concerns. Yeah, I think we have. Gina L. What the flock you say? Said origin, the term chambers was first used for a judge's private office in the 17th century England when judges were given the power to conduct legal business outside of formal court sessions. So it was an in-chambers conference. That makes sense. Elizabeth Me said, how could anybody think someone would not fight for their life? I don't know what was going on in the weeks right after John O'Keefe's death, but if I tried to, I have a hard time envisioning. There's often times when I look at a DA's office and I'm like, oh, they're probably going to do this. They're going to argue that. The defense is going to argue that. I have a really hard time in this case because everything is so like, wait, what? But I wonder if because to them it all seemed so obvious, they were just like, oh, well, obviously. That they couldn't even conceive that there might be other options. Andy in the chat said, if she fights, it will be an episode. Yeah. No. Weren't they wrong? It's not an episode. It's freaking One Piece at this point. It's not an episode. It has 17 different story arcs. Some of them are more popular than others. And we never know when it's going to end. It is more than a series. It is seasons on seasons. Lona said it's an anthology. I mean, for real. It is a epic saga. with so many, it's like JoJo's, where you have the different characters get their own like series of books and you're just spinning into different parts of the same thing. It's a whole cinematic universe at this point. It is. So that. Aiko, do I watch One Piece? Not regularly, but they did the remake, like live action one that my kids really enjoyed. So we did that. And my kids have been more invested. I can handle about the, like, even with the housewife stuff, I'm getting exhausted. I'm like, we are way too deep into all of this. Like Supernatural is an extended series. And that's about, when I'm looking at a series, I'm like, yeah, long, strong. And I'm like, however, I really enjoyed the live action with the kids, but there's a lot of investment into One Piece. So I'm I'm aware of the world, but have I watched all? No, I have not. So we also have so much to cover in the Kouri Richins case. We have so much to cover in the Kouri Richins case. And I think we should get to getting. We really need to get to Utah because it is so much. And we're going to be back in Massachusetts on Thursday. Don't worry. Also, Daniel in the chat said, no nudes yet, huh? I mean, it was just an expectation. I am sure they found some of Proctor on the phone. Probably not in the text messages, but I am sure that also exists. I would not be surprised. And now the prosecutor's office has them. So yes, Proctor, I'm sure that you are the subject of many unflattering conversations. Probably the least of your concerns at this point. Trying to figure out if a one-way ticket is less expensive would be my guess. But that's hyperbole. So we need to fly to Utah. We do. We need to fly to Utah because we also we have to fly to Utah. And then I will try to give a summary of what we need to talk about today. And you're going to go, we're never going to get to all of that. We're going to do our best. I'm optimistic. So, Law Nerds to Utah. For those of you not familiar with the Kouri Richins case, don't worry, we will do a brief summary before we get into everything that is happening. Remember, the Richins case did have a bit of a delay because there was a motion to change venue, and then that motion went through the appellate court process, and now it is back before the judge. But during all of that, the case was stayed. So there was like a pause. Wait a minute. So there are a lot of motions ongoing that have not been decided yet. And then there are new motions ongoing that have not been decided yet. Is there a next court date? No, there's not. There's going to have to be one because there are a bunch of motions happening. Kouri Richins is accused of poisoning her husband in an attempted murder on February 14th, and then an ultimate fatality of her husband on March 3rd, 2022. She was not arrested until May of 2023. It took them about a year because it took them that long to crack her phone. So they tried to do a download of the phone. There were some questions about the download of the phone. Then they needed updated software to download the phone. And then there was a re-download of the phone. And then there was an arrest after getting into the phone. So it took over a year to arrest her. During that time, she wrote a children's book. Yes, like a real children's storybook about grief after her young children and she experienced the loss of their father. So as she was on local TV and such, promoting that book about how they were navigating an unexpected death of a young and healthy individual. She was arrested for his murder. There is a second criminal case pending that deals with mortgage fraud and forgery and false statements to banks and what have you. So there is a separate criminal case involving all of the monetary and mortgage fraud, girl bossing too close to the sun and right into fraud. The background and underlying motivation the prosecution has asserted for that murder is that she was just flipping houses and living her best and was in such a pit of unserviceable debt at the same time that she was having an extramarital affair, referred to as the paramour in the motions from the prosecution, that she also, it seemed, was becoming aware that maybe her husband wasn't feeling it in the marriage, and that the prenuptial agreement indicated that should they get divorced, all of the premarital property would stay with the husband, including his successful business. If the husband died while they were married, then she would get his half of his successful business. And during the same time, she was using his business bank accounts to forge loans, etc. So she knew how much money was in his business account because she was taking her husband's business bank statements and literally forging them by cutting out the heading for her banking and putting it at the top. So it looked like her bank statement, and then putting her digits at the bottom. So the in between was the husband's bank statement, and the top and bottom looked like her bank statement. So she was using his banking information to get loans into her business. She also was taking out life insurance against him. She was taking out loans against the house that was owned premaritally and in his name, etc. So the financial underpinnings are what the prosecution alleges is the motive for the murder. There are also text messages back and forth with the paramour regarding her imminent availability. There is also that walk the dog letter that we have covered so much we can't cover it again, but there's still a motion pending about whether the walk the dog letter will come in as evidence or not. I'm interested to see that hearing, but the walk the dog letter is Kouri Richins telling her family members, hey, say this, it would help. Tell the lawyer this, it would help. Remember. So, all the things with Kouri Richins. That's right, she was getting her cabinets installed on Valentine's Day. When her husband was like, I'm not feeling well, and she's like, oh no. So if you are fascinated by this case like I am, well, yes. Where are we today? Well, there have been lots of motions by the defense. Remember, the defense attorneys went, the star witness, this is the defense's couching, not mine, the star witness has recanted. And there is, the prosecution's case is crumbling before our eyes. And Kouri must be let out of custody. She has remained in custody without bail since her arrest in early May 2023. The delay in the case, first she switched attorneys, then the extended motion to change venue with appeals. So they're like, look, this witness has recanted. You must release her, and you must order the prosecution to turn over exculpatory evidence, and you must, all of the things. So the defense made numerous motions. We went through them, how the defense feels about this information, how I feel about this information is different. Do I think this information is the entire case is falling apart? Not just based on this. No. But do I think that if a witness changes their statement, the defense should know? Yes, they should. Do I think it's a change of statement that is hugely impactful? It depends on the jury. So those are the motions we are jumping into today, and then we will see if we can get to more, because guess what? The defense is also trying to subpoena Kouri Richins' sister-in-law, the one that Kouri Richins attacked. The sister-in-law who's the executor of the estate. So Kouri's attorneys are trying to force the sister-in-law to comply with turning over information and a subpoena. So there is another motion pending regarding the sister-in-law, the one that got throat punched, 100% Cheryl Ray, the one that got throat punched. So the sister-in-law has been dragged into this as well. If you haven't seen the bail hearing, go watch the bail hearing. If you're like, Emily, I haven't caught up on this case, there's a whole playlist. Just start at the beginning. Because this case it's a lot. So, a lot of you are like, why was the sister-in-law throat punched? Okay. From what we can tell from the evidence, Kouri didn't know that the victim, decedent in this case, her husband, Eric, had thought it was really weird that Kouri was like taking out loans on the house that he didn't know about, etc. And so he took all of his separate property per the prenup and moved it into a living trust, and I think a pour-over trust, and some other more complicated estate planning. Either way, when he passed, all of his things went into the trust. So it poured over instead of just being divided up to her. The trust benefited the kids. There are still estate law cases going on to determine what will happen with the property and what will happen with the estate, including the home. That is all being litigated. Most of it's on pause until after the murder case is done. So when sister-in-law showed up and Kouri was trying to get into Eric's safe and trying to get into other things, sister-in-law's like, this shit ain't yours. That's not what she said. I'm paraphrasing. And Kouri lost her ever-loving mind and literally went like berserker on sister-in-law and throat punched her. And we saw text messages about it where Kouri is retelling losing her shit on sister-in-law. And we saw in letters Kouri Richins telling her mother the way to get after the sister-in-law is to go after the kids. And sister-in-law testified to it at the bond hearing. So, yeah, it's a lot. So Tom fought off an intruder and they injured his eye, and then he was driving and he flipped his car and he hurt his ankle and he was in the hospital. So yeah, it's a lot, under a lot of stress. For those of you that are like, Emily, what are you on about? Real Housewives of Beverly Hills. I need to just clip Erica's speech and put it on the soundboard. It's probably too long. So the first thing we're going to look at is the prosecutor's response to the order to compel. The defense filed their motion saying, give us that new witness statement, amongst all the the world is falling. The defense says that the witness who sold fentanyl to the go-between who gave it to Kouri or sold it to Kouri, he originally said, yes, I sold fentanyl to the other woman who sold it to Kouri. And then later he said, no, it was just Oxy or Roxy's. I didn't sell her fentanyl. And I didn't even know what I was saying to the police the first time because I was in withdrawals from fentanyl. So I didn't even know. And I wasn't selling that at that time. So I sold Oxy, not fentanyl. So the defense is saying this is huge and the prosecution didn't turn it over to us and we only found out because we went and interviewed the witness. I think it's a change of witness statement. Do I see that as a recanted statement? No, I see it as a change of statement. He didn't say I didn't sell anybody anything. He said I did sell her that. I did sell her I sold the go-between narcotics. It was the other one. It wasn't that one. So that is what the defense filed. We're going to take a look at the prosecution's response, we also have that bail motion that is all tied into the same thing. And then we have a motion filed by the witness that's being discussed here, who now has a lawyer. And then we have witnesses, and then we have motions with regard to the sister-in-law. Thank you, Ariana. Tom's house was broken into and he confronted the burglar, and then he had to go have eye surgery, and then my son had to go over and help him, and then my son, he rolled his car 5 times on the way home. So yeah, I'm under a little bit of stress. Thank you. Thank you. Let's take a look at the prosecution's response. Yes, the prosecutor's name is Brad Bloodworth. No, it's not just for spooky season. It's true. Vicky with an eye said, will we ever see the Paramore if this, I mean, not in concert, but if this goes to trial? I suspect the state will call the Paramore to validate the text messages. State's opposition to defendant's request for order compelling disclosure of exculpatory evidence. Emily, rapid fire reading goes better. Say Something said, is this Judge McDreamy? Yeah. With the beard, though he had shaved the beard and it was very disoriented, but with the very, very deep voice, who also hates this case being a media case. Yes, that judge. It's that judge. Oh, let us continue. The state of Utah requests that the court deny defendant's request for order compelling disclosure of exculpatory evidence because there is no undisclosed exculpatory evidence. The state and its agents have met with Robert Crozier twice. First, 2 detectives interviewed him on May 4th, 2023 at the Davis County Jail. Kouri was arrested May 8th, 2023. So like 4 days before she was arrested. Interesting. The state has provided a body cam video of that interview to the defense. Second, Chief Prosecutor Brad Bloodworth and Chief Investigator Travis Hopper. Lots of Travises today. Travis is going to be thrilled. I was telling my kiddo that one of the reasons that we named him Travis, other than liking the name, is that it was not a super popular baby name during the time he was born. He's not named like Hayden, Aiden, Braden, Caden. So it was not the most, like, Travis definitely stood out amongst the other children in his class. And he was like, yeah, and Jaden, yes. He was like, it's not a super popular name. I'm like, yeah, and then Taylor Swift got engaged. So there will be, I imagine, there will be many a Travis in the years to come. It's going to become a much more popular baby name again, but it has its ebbs and flows of popularity. But it's hilarious because even within his friend group, Aiden, Braden, Caden, Hayden, Jaden. All right. So Brad Bloodworth and Travis Hopper met with Mr. Crozier on March 28th, 2025 to prepare him to testify. The state possesses no exculpatory evidence from that meeting to provide to the defense. Look, man, if the witness changed his statement or clarified his statement, just turn it over. Why are we fighting over this? Just stop it. Just stop it. Karen in the chat said, try having my name. I know, it's so unfair to all of the Karens. It really is. It really is. Remember when Edward and Jacob became the number 1 boy names after Twilight? 100%. 100%. So Amelia said my name was picked because my mom liked Emily, but everyone was named Emily. It's also fair depending on age. There were not a lot of Emilys my age. There were a lot of younger Emilys than me. They all go to the same Starbucks I do, apparently. But my mom wanted to name me something else. I think Katie. And there were lots and lots of Katies. And then one of her good friends had a Katie. And then my mom was like, well, shit. We can't have 2 of them like 3 months apart. That's not going to work. So the prosecution's like, yeah, no, we have no exculpatory evidence. Tough. The defense responded. How do you think the defense responded? Do you think they are thrilled at this statement by the state? Right. Right. The defense is less than stoked with this response. So let's get to the defense reply to the state. The state is just like, trust me, bro, we got nothing. The state, I suspect, is a bit more fulsome in their response, to the motion for bond. But like, trust me, bro. Defense, your turn. Defense reply. We already started badly. Defense reply to state's opposition for defendant's request for order compelling disclosure of exculpatory evidence. At least it's easy to tell what motion is what. In its request for order compelling disclosure for exculpatory evidence, defense counsel moved this court for a standing order imposing a 3-day deadline on the prosecution to disclose the following to the defense. 1, all evidence, including emails, text messages, phone messages, recording, video footage, or any other form of correspondence involving the prosecution teams or any law enforcement official and Robert Crozier. That's not going to happen. Including correspondence about setting up a meeting or any sort of summaries of the meeting. Summaries of the meeting, I think witness statements should be turned over. But they're not going to get emails, text messages, and the rest of it. No. I mean, unless the witness gives them to them, he can do that. But no, that's not going to happen. And the court has not made this order. But yes, if you meet with the witness and the witness makes a statement, the witness statement should be turned over to the defense. Just period. What are we doing? 2, all notes, correspondence, or reports prepared by law enforcement officials or any member of the prosecution team discussing the interview. That's not going to happen. Any statements, recordings, reports, or notes in whatever medium, including emails and texts that tend to negate guilt, exculpatory information has to be turned over. There is going to be a big disagreement about whether a change in statement in this way is exculpatory. I think witness statements should be turned over. I do not think that it's exculpatory. They will disagree on that. That's fine. I still think a change in witness statement should be turned over. He said, oh, I told you it was this, and now I'm telling you it's this. Turn it over. But you're not going to get all emails and texts, but anything exculpatory does get turned over. Defense also requested an order requiring prosecution to disclose on the record, or to reduce to writing, and provide the defense all oral statements discovered when interviewing witnesses that tend to negate guilt or contradict prior statements made by the witness. I don't disagree that there should be a summary of what was said, including those witnesses interviewed in preparation for the last trial setting. In its opposition, the prosecution stated that the defense request should be denied because there is no undisclosed exculpatory evidence. It submitted 2 affidavits in support of their opposition. I think both of them were sealed, though there are also affidavits, I think, with their other response. And I think they went to both. So we will see affidavits that aren't sealed, but there were sealed affidavits as well. It submitted 2 affidavits in support of their opposition. The state did not deny that they did not provide Crozier's statement that he never sold fentanyl, only OxyContin, to Carmen Luber, CL, but rather determined that it was not exculpatory. This was not the state's determination to make. Unfortunately, it generally is the state's determination to make if it's exculpatory or not. I think it is a change. The defense disagrees. That is why the court is going to have to decide. Clearly, they say Crozier's statement recanting that he sold fentanyl is more than potentially exculpatory. There's the word, potentially. Yet it was not provided to the defense. Therefore, the state should be required to turn over all statements made by witnesses as stated above. I mean, don't witness statements get turned over? Like what? If the witness statement is I'm available to testify on Wednesdays, not Thursdays, no. But if they're talking about the case, yes. We met with witness this day. We discussed their prior statement. They clarified this. I think that should be turned over. I'm going to stop saying it. I disagree with how the defense sees it, but I still think it should be turned over. Therefore, the state should be required to turn over all statements made by witnesses as stated above, so the defense has all potentially exculpatory evidence prior to trial. I need to look at the words of Utah's code. Are they not required to turn that over? Like, that would be weird to me. But I need to look at the code. Because again, that would be weird. It goes on to say, further, the prosecution did not articulate any objection to the defense's standing order request. They didn't. They said that there's nothing to comply with. With no objection to the standing order, the defense requests that the court grant the motion for the standing order. Mr. Ramos is like, they didn't say no, grant it. Immediately, grant it immediately. Summaries of witness interviews should just be turned over. I said I wasn't going to say it again. There we are. The defense also made a bail motion. We are going to talk about the state's opposition to the bail motion and then the defense reply to the bail motion before we get to anything else. And these were all filed by the state at the same time. I don't see affidavits on this one either. I think all the affidavits were sealed because there were numerous sealed docketed items filed at the same time. So when those are referenced, we do not have them. But in this response, I think we'll see a little bit more of that information. Remember, the defense says everything has changed. This witness said that he didn't sell fentanyl, only OxyContin. Their entire case is crumbled. That was the defense's argument. It was a bit, the language was a bit strong for what it is. However, this is the state's response to that. State's opposition to defendant's motion to reconsider bail and conditions of release. State's preferred disposition and grounds. The state of Utah requests here. I can make this a little bit bigger. And begin. It's so clear and easy to read. Until I do that. The state of Utah requests the court deny the defendant's motion to reconsider bail and conditions of release because Robert Crozier's recent assertion that he, quote, understood that the pills he sold to CL contained only OxyContin does not amount to a material change in circumstance. I don't disagree. I think it is a change in statement. I also think that it's probably something that they will argue at trial because he's on video making the other statement and then the jury gets to decide. But I think, can I imagine a world where somebody currently in custody for selling narcotics would distance themselves from selling one type of narcotic over a different type of narcotic? 100%. I 100% can see a world where he's like, nah, I sold this, not that. Sure. The long and short of it is the witness says he still sold pills to CL. CL gave those pills to Kouri Richins. And then the victim died with tons of fentanyl in his system. So I don't think it's a material change of circumstances. Also, the victim did not die on Valentine's Day. And then we have seen that Kouri Richins reached out to CL and said, I need something stronger. We also saw that Kouri was asking for whatever. Kouri was like, do y'all have some of that Michael Jackson stuff? Everybody's like, no, we don't have street propofol. What? Then she was like, do you guys have any pain pills for like back pain? Do you have any of those pills? Do you have stronger pills? I'm going to need stronger pills. So I think the circumstance is substantial. Heather, this is a good question. Heather said, are we sure that was her only dealer? They have her phones and most of this was tracked back by phone. So I imagine they don't have any indication on the phone that she was asking for anyone else. And the other person she had asked said no. So she had asked someone else and they were like, "Bitch, what?" They didn't say that. But no. So the prosecution is saying, look, the change in statement or the recent assertion is that Crozier, quote unquote, understood the pills that he sold to CL to contain only oxy does not amount to a material change in circumstance. For the bail, I agree. Regardless, substantial evidence exists to support the aggravated murder charge, notwithstanding Crozier's recent assertion. Statement of relevant facts. 1. In February 2022, Mr. Crozier told CL that he could get her fentanyl, and on 2 occasions that month, she purchased from him what she believed to be fentanyl. And this is from her statement. And then they cited where it was in transcript. On May 4th, Summit County detectives interviewed Crozier. He was certain that he sold fentanyl. Detective, quote, "But you sold CL M30s, right?" Crozier, "Yeah, I sold her what she knew what she was buying." No, he doesn't want to say it. Why would someone not want to admit to what they are selling? I don't know, because they don't want to get in trouble more, especially if the state is cracking down on fentanyl. What you don't want to do is tell detectives that that's exactly what you were selling. Shock me. Detective, it wasn't like she was asking for oxys or something like that and she got the M30s. And Crozier, right, no. So she knew that there was fentanyl in those pills. Crozier, absolutely. Okay. The jury will get to decide about this witness statement. I think it will be fought a lot at trial. I don't know how much it will matter at the end of the day. Is it a material change in circumstance that's going to let her out on bail? No. Is it a change of statement? Yeah. In September 2025, Crozier recanted his interview with detectives during an interview with defense counsel and asserted that he sold CL, quote unquote, blues that he got from an unidentified, quote unquote, source, and that in early 2022, he, quote unquote, understood blues to only contain oxy and that he did not, quote, come to know that blues also referred to fentanyl until late 2022. How convenient. Argument. And this is the state's argument. Crozier's recent assertion that the pills he sold CL contained only, bold and italicized, OxyContin does not withstand modest scrutiny. Well, okay. Also, would it shock me that almost anything being sold illegally at this point contains fentanyl? No, it doesn't. Like, just, that wouldn't surprise me at all. Anyway, the state goes on to say he doesn't know the composition of the pills because, as the defense often notes, they were never tested. I mean, right, the pills weren't tested. The only thing that was tested in any of this was Eric Richins after he was deceased. But the street dealer is not testing the pills. The state goes on to say he was a low-level street dealer who got the pills from an unidentified source at a time when nearly every pill on the street contained some amount of fentanyl. Right? Awesome. I'm going to get the rest of that wrong. Awesomepotamus. Has Kouri ever claimed to have addiction issues? No. Kouri claimed that Eric, the victim, would get marijuana gummies or weed edibles, and that she thought that the edibles must have been laced with fentanyl. And then law enforcement tested the edibles and they were not, in fact, laced with anything. So that she said the victim must have been exposed in a weed gummy, but the victim also had Kouri's prescription in his system. So she had a different prescription that was in the victim's system. So there's that. So the prosecution argues, and I imagine at trial they will have a law enforcement officer talk about because the jury might not know that a lot of narcotics on the street are laced. The jury's going to get a lesson about that a little bit, about how everything is laced. So, Kim said, Emily, is that something they will tell the jury about how she said it was a gummy? Oh, 100%. How she told police in interviews it must have come from laced edibles. And then they'll bring in a narcotic detective to talk about the issue with everything being laced with fentanyl before, I would imagine, they bring in this witness. Crozier's recent assertion is further, this is, as we get into why Emily thinks that they should just legalize weed everywhere so it stops getting laced with all kinds of shit that's dangerous. When not properly dosed and regulated, it would just make it easier for everybody, but what do I know? Going on. Crozier's recent assertion is further impeached by the May 2023 interview in which he denied that he sold Miss Luber oxys. He affirmed that the M30s that he sold her contained fentanyl, and she absolutely knew that they contained fentanyl. CL corroborates Crozier's interview with testimony that she asked him for fentanyl and believed that that's what she received. Ultimately, of course, Crozier's interview is corroborated by a constellation of means, motive, and opportunity evidence against the defendant, and the toxicology results showing that Eric Richins, the victim here, died of fentanyl poisoning. Crozier's recent assertion does not amount to a material change in circumstance because it is not credible. Again, going to go to the jury to decide. Regardless, it does not detract from the substantial evidence that the court has twice found capable of supporting a jury finding that defendant is guilty beyond a reasonable doubt. A reasonable jury could choose to completely discredit Crozier's recent assertion for the reasons stated above or assign it de minimis weight in comparison to the weight of the evidence well established in the record that defendant committed aggravated murder. At bottom, apple bottom jeans, boots with the fur. One of my least favorite legal phrases, Mr. Bloodworth. But I digress. Chat will suggest some alternatives, or maybe everybody just likes to giggle with at bottom. A reasonable jury could consider Crozier's recent assertion and still easily convict the defendant. Yeah, I just thought I was selling her this. She asked for fentanyl, I was just giving her this. I mean, who knows what's in those pills anyway? Pills went from Crozier to CL to Kouri. And then the victim's toxicology report shows like 5 times a lethal dose of fentanyl in his system with Kouri's prescription and no weed. So, Conclusion. The court should deny the motion because Mr. Crozier's recent assertion that he sold pills to CL that contained only OxyContin lacks sufficient credibility to amount to a material change in circumstance. Regardless, substantial evidence exists to support the aggravated murder. Brad Bloodworth. So, aggravated murder just being first-degree murder in this case. I think so that's just the title of the intentional, volitional murder in Utah. Utah also does, Utah, get me too. I saw some of you in the chat earlier. Utah, get me too. Utah also calls some of the narcotic cooking charges clandestine chemistry. One of my favorite things is the clandestine chemistry charge. So different jurisdictions call different types of things different, whether it is first degree murder, aggravated homicide, etc. So it's a good band name. Clandestine chemistry is such a good band name. All right. So the defense replied, how thrilled do you think they are? None at all. The defense is none thrilled. I haven't read this, so I have no idea. But I'm just going to guess that the defense finds that argument lacking a bit, perhaps. All right, the defense responded. This was at the end of last week. Oh, they started with a quote. No. What date was this signed? 23rd of October. Do you remember? 23rd of October. So last, Thursday? Defendant's reply to state's opposition to defendant's motion to reconsider bail and conditions of release and request for a hearing. I want there to be a hearing too. Quote, truth is not what you want it to be. It is what it is, and you must bend to its power or live a lie. I said the defense motions were getting too heavy-handed with the hyperbole, and they were just like, lean in more. Lean in more. Lean in more. I'd commend the chat said, imagine a clandestine chemistry collab with My Chemical Romance. I mean, they're both kind of about the same thing, I think. Wasn't My Chemical Romance the beginning of the title of a book? The defense. In arguing for Ms. Richins' detention, the state claimed that CL purchased fentanyl from Robert Crozier and provided it to Ms. Richins, who then somehow got her husband to ingest a fatal dose without his knowledge. She made him a drink, but he also had other drugs in his system. Things that were prescribed to Kouri Richins, where drowsiness is a side effect and sometimes the desired effect, but okay. Sure. Getting him to ingest it, well, that would be the second time, wouldn't it? Based on the state's allegations. They go on to say, the state has conceded that these alleged pills have never been located. They've been digested. Also, in most ODs, which is sad to talk about, but in most ODs, you see the thing that the person has OD'd on near them. Law enforcement found nothing. Nothing. At all. So it's not giving OD. It's not giving accidental OD. There was an overdose. It is not giving accidental overdose. So the pills were never tested. I wonder why the pills were never tested and the pills have never been located. So weird. If they're going to argue that at trial, it's going to be like the pills were never located. Ask Kouri where they are. Or were they all dissolved in a drink? Because the breakfast sandwich didn't work. He got super sick on Valentine's Day. He told his friends he almost died. And then she reached out to CL and said, I need something stronger. And I 100% surmise, this is my own speculation after paying close attention to this case, that Kouri Richins was like, I have been lied to by the news. The news says anybody sniffs fentanyl in the direction of something and they die. And he is not. I don't mean to be crass, but I think that's what she thought. Like, what do you mean? He survived. I have been lied to by the news. Everyone talks about how fatal it is. Why is it not fatal? I 100% think that that's what she thought. And then asked for something stronger. And then her story to the police and how much she's moving around the house don't line up, because your Apple Watch and your phone are going to tell on you. She said she was asleep in her kid's room. She went back to her room and then immediately called law enforcement. But that's not what her activity on her phone shows. So could everything have just ended up in the toilet? Yeah, it could have. Does it matter? Not really. Because the autopsy is pretty clear. So, go off, I guess. The somehow got her husband to ingest it. Her statement to law enforcement was she made him a drink. How in the world could you ever? So weird. The state has conceded that these alleged pills have never been located. The state has never claimed that CL tested these pills or had personal knowledge of their chemical makeup. Mama Empath, Jenny G in the chat said, imagine poisoning your husband on Valentine's Day. Well, and when he was messaging her that he wasn't feeling well, she was with her paramour and she was lying about being at a house that she was flipping. I'm going to stop making flipping jokes. Emily, let it go. She lied that she was at a house she was flipping. She was with her paramour. And she was like, oh no, just lay down. You'll be fine. The defense goes on to say, the state has continuously relied on their argument that CL's testimony that she purchased fentanyl is reliable in large part because it's corroborated by other witnesses. And the autopsy. And the autopsy. And the autopsy. Big Fart said, wait, she was cheating. I completely missed that. Yes. La Sancho. She had the state refers to him as a paramour, but yes, full OPP. She said she was waiting to get cabinets hung in a house that she was renovating. So, at least Emily, let it go. Let it go. Let it go. We're gonna let it go. Moving back to the defense argument. They say that CL's testimony is corroborated by other witnesses. I would say, and the autopsy. The defense goes on to say this claim of corroboration has been pointed to in the state's pleading and testimony regarding these corroborating witnesses and was elicited by the state from Detective O'Driscoll at the preliminary hearing. See attached transcript. We covered that together. The state has relied on only one of the corroborating witnesses, Mr. Robert Crozier, to testify that the pills provided to CL were in fact fentanyl. And the autopsy! They go on to say, the state relied on Crozier to testify that the pills provided to CL were in fact fentanyl. He is the only witness who could potentially claim a direct connection between fentanyl and Miss Richins. Other than the only other individuals in the house this evening were young children. So I just disagree with the fundamental premise of the defense's argument. They are doing their job. The defense goes on to say, however, now that Crozier has stated under oath that he did not provide fentanyl to Miss Luber, the state is asking the court to find that one of their most important witnesses is no longer credible. No, they say the updated statement is not exactly credible. I provided pills, just not those pills. Okay. The defense goes on to say, although ultimately Crozier's credibility will be determined by a jury, at this stage, it is in the providence of the court to listen to Mr. Crozier and make that determination. I don't think this gets them across this is a trial issue. This does not get them across the threshold for a change of bail. I don't think it's a change of circumstance. I don't think they even get a hearing on this, truly. You have to have a change of circumstance before they can re-argue bail. I don't think this gets them there. Him saying, no, it was different pills is not a change of circumstance. They think the court should listen to Crozier. Ultimately, Crozier's credibility will be determined by a jury. At this stage, it's for the court to listen to Mr. Crozier and make that determination. Notably, it is never the job of the prosecution to determine the credibility of a witness. I mean, the prosecution kind of has to determine the credibility of their witnesses when they decide to file a case. Like if they determine a witness is not credible, then that's the only witness they need to make those determinations. But okay. The defense goes on to say not for the purposes of bail, nor for any other purpose. Should this court find Mr. Crozier's testimony to be credible, the weight of the evidence in this case will be significantly changed. I also disagree. From that which existed at the time of the last detention hearing in this matter. The elimination of the state's alleged link to fentanyl to the defendant is a material change in circumstances, and without it, the state can no longer claim the existence of substantial evidence sufficient to support a denial of bail. I just disagree. Because you have Kouri texting CL, hey, can you get me something stronger? And then you have CL's text asking somebody for something stronger, and then CL brings back pills and gives them to Kouri. Even if you take Crozier out of the entire thing, and CL goes, I asked for this, I bought things, and then I gave them to her, that's leading up to the death of Eric Richins. So I don't think this undermines the case the way the defense hopes, but they've gone a long way to make that argument, so you can't say they're not trying. They're just not going to make fetch happen, from my perspective. The defense then says, because the state, after they quoted case law with regard to the substantial evidence bit of bail, they go on to say, because the state is now placing Mr. Crozier's credibility into question, the defense is requesting an in-person hearing to enable the court to observe Crozier's testimony and demeanor and to decide whether Mr. Crozier's credibility is sufficient to support Richins' claims that there is no longer substantial evidence to support a jury verdict of guilt. Such a finding would require the setting of bail as a matter of law. I don't think they're going to get the hearing. For the reasons stated herein and in Ms. Richins' motion to reconsider bail, the defendant respectfully requests that the court schedule a detention hearing as soon as practicable and release Ms. Richins on a combination of bail and conditions. I just don't see that happening. I think the most reasoned response to all of this, and I would need, of course, to look at what is required to be disclosed in Utah. But I think the answer here, and this court has been very reasoned, is a witness change of statement needs to be turned over to the defense. The defense needs to be provided and must be provided and shall be provided a summary of what was said in that meeting. But this is not a change of circumstance that even warrants a bail hearing. So no, there's not going to be a bail hearing. We haven't crossed the threshold to get a bail hearing. You haven't been invited in. Mr. Bloodworth says, no, you have not been invited in for a bail hearing. You may not cross the threshold. No hearing for you. And I don't disagree. There should not be a bail hearing in this. But turn over the witness statement. Sure. That's where I think the court will go. We'll see what the court does. The court has not set a hearing on this. The court has not set a date on this. When they do, we'll talk about it. But we're not done. M. Barr said, but didn't he have a huge amount in his system? The victim had like a 5x lethal dose of fentanyl in his system. He had a substantial amount of fentanyl. But I think more telling than that is that he also had Kouri Richins' prescription in his system. Her Seroquel. Weird. But the defense not only wants bail, the defense also wants a bunch of information from Kouri Richins-Benson, the executor of Eric Richins' estate and sister-in-law, former sister-in-law of Kouri Richins. So we need to take a look at what the defense is trying to get from the sister-in-law. Allie said Seroquel will make you super tired, especially if you're not used to it. Look, I think the prosecution will argue that on Valentine's Day, they're going to be able to get into Eric Richins' present sense impression statements that were made to his immediate friends saying, I almost died, I was this sick, blah, 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 blah. I think they will bring in a medical expert to say that the things Eric Richins was describing is consistent with the type of allergic reaction or the type of autoimmune reaction, I might be saying that wrong, that one can have to opioids. And I imagine the expert will not be able to determine whether that is like an Oxycontin or like a fentanyl, but that this is an opioid response. We see that type of response with these things. And I think we will see an expert testimony about the things that Eric Richins described. Eric Richins was given a breakfast sandwich that his wife went and picked up from a nearby diner. I assume that they like because it's Valentine's Day. Like, I went and got you a breakfast sandwich. Fantastic. And then he ate the sandwich, didn't finish it, got sick, and then recovered. So then she asks, per the prosecution's filings and prelim, then she asks CL for something stronger. Then CL meets back up with Crozier at the Maverick in Draper and gets something else and gives it to Kouri in the days leading up to Eric Richins' death. And then he has in his system the Seroquel and the fatal dosage plus of fentanyl. And Kouri Richins' statement to police is, I made us drinks. Like, she made her a drink, she made him a drink, I made us drinks. And then he went to bed, and then I went to sleep in one of the kids' rooms, and then I got back to the bedroom, and he wasn't breathing. That was essentially her statement. So when you look at all those things together, you can see that she's modifying her approach and delivery method. That would be my argument if I was the prosecution. So I think that them saying what Crozier has to say is the crux of the entire case, what Kouri has to say is the crux of the entire case. Kouri's text messages are the crux of the case, not what Crozier has to say. That's how I see it. we'll see how it comes in trial, because what's argued in motions and how the evidence comes out in trial is not always the same thing. But we've seen the bond hearing with quite a lot of evidence and the prelim with quite a lot of evidence. But the defense is tracking down potentially every avenue and is looking for more information. Where is my mention at all? Where is it?
Why is no one ready?
That's me. I'm not. Where?
Mention it all. Mention it all.
So, the defense is looking for more information from the former sister-in-law. This was filed, Emily, what date? This was filed back in June. The reason that the response just came in, and the response just came in last week, is because the case got stayed in between. This was filed right at the same time that the change of venue motion was going up on appeal. So it got paused till now. So let's go back in time to June to take a look at what the defense team is asking for from the sister-in-law, because the court has been asked to compel Eric Richins' sister, executor of his estate, former sister-in-law of Kouri, Kouri Richins-Benson, to comply with an SDT, subpoena ducis tecum, documents. Give us documents. Comes now Kouri Richins and asks the court to compel Katie, because the names are going to get confusing, Katie, victim's sister, to comply with the SDT served upon her by defense in the above styled matter, this murder case, and submits as follows. Katie was duly served a SDT in this matter by undersigned counsel for the defendant pursuant to Rule 14B of the Utah Rules of Criminal Procedure and Rule 45 of the Rules of Civil Procedure. Counsel for Katie timely responded and partially complied by producing various documents and videos. However, counsel objected and refused to comply with multiple requests contained in the subpoena. See attached. Love it. For purpose of this motion, the defense is seeking to compel compliance with the following specific requests. All documents in your possession or control showing the financial activities of the Eric Richins Living Trust dated November 3rd, 2020 from March 3rd, 2022 to present. Why? I want to know why. Why do you need the financial behavior of the trust in defense of this murder case? This is happening after, like, from the date of the murder forward. Why? In responding to this request, please provide all documentation showing trust liabilities, receipts, loans, disbursements, deposits, income, expenses, gifts, and payments of any kind made by the trust to any person or entity. Such documentation should also include all periodic bank statements for accounts owned by the trust or its successor trustee in her role as successor trustee, and should include documentation of any trust activity for trust assets held in any attorney's IOLTA trust accounts. Such documentation should also include tax returns, check stubs, deposit slips, check copies, ledgers, wire transfer confirmation, and any other electronic mechanism or application utilized by the trust. No, Kouri can go get the trust documents in the civil case when the civil case moves forward. I don't see how this is appropriate for the criminal case, because if they are seeking to argue the trust didn't even have all that much money anyway, it doesn't matter what was in the trust. It matters what Kouri thinks is in the trust. So I don't see how she's entitled to any of this. And I don't see why. But I'm interested to see why they are arguing for it. It goes on to say, any copies of checks drawn out of your personal or business checking accounts made payable to any individuals connected in any way to the investigation or prosecution of Kouri. What? What? Representatives for Katie objected to request number 5 and 6. Not 6, 7, chat. Not 6, 7, 5 and 6. 6, 7, not 6, 7. On the grounds that they believe Ms. Richins' civil counsel has previously produced accountings for the trust, that the requests are vague and ambiguous, that they pose an undue burden, and that Kouri Richins is not entitled to these records. I don't disagree. Because she is not a beneficiary of the trust. While it is true, the defense goes on, that Ms. Richins' civil attorney has produced some documents to the defense team, footnote 1, those documents consist solely of a general balance sheet containing no individual breakdowns of individuals paid by the trust, and a general accounting report, which also provides sparse information about which individuals have received direct payments from the trust. It's none of your business. It goes on to say, these previously produced documents provide no information about payments made to witnesses in this case by the trust or by Katie personally. What is the good faith basis for that? But you see what's being insinuated, right? Footnote 1. Because the documents produced are under seal and for attorney's eyes only, or AEO, this motion shall refrain from attaching or citing specific portions of those documents. However, these matters can be discussed in a closed hearing as required by the court. They go on to say, documents reflecting monetary payments made by the trust or funneled through Katie's personal bank accounts or her attorney's client trust accounts to state witnesses in this case are material to the defense of this case, go directly to the credibility and bias of state's witnesses, and should be discoverable pursuant to the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and the Utah Constitution. What in the world? Okay. They go on to say, as of this date, the state has not produced any of these documents to the defense, and the defense is unaware if any of these documents are within their custody or control. I imagine that the trust documents are not within the custody or control of the state because they don't care. This has nothing to do with them. I don't even think the state can get to some of those information, to some of those documents. These requested documents are not publicly available. No shit. They're sealed in another case. Therefore, an order compelling Katie to comply with the production of these documents is the only way for the defense to obtain these records material to the defense. But, Your Honor, we want to know.
Mention it all. Mention it all.
Come on, Your Honor, mention it all. We want to know. It's Mustard in the chat said, not me just now realizing I'm watching EDB live. I'm always on the replay crew. Got to mark this day on my calendar. Wherefore, premises considered, this court should compel compliance with the SDT, the request for documents. Additionally, a hearing should be set wherein she should bring the subpoenaed documents or show cause why she has not complied. Your Honor, make her come to court and explain. Make the lawyer come to court and explain. And then they attach Exhibit A, the request for a whole bunch of stuff, and then the response from the attorneys. So this was from July 30th from the law firm for the trust. Well, for the trustee and for the trust. Counsel. I really wish this was like at least 1.5 space, but we're like back in the world of civil where it's just everything is just so much text. Counsel. Law firm. BTJD. Bennett, Tuller, Johnson, and Deere. In John Deere Green. There's an old cut for you. If you know the next lines, drop them in the chat. We've covered many genres of ADHD singing today. Bennett, Tuller, Johnson, and Deere represent Katie individually in her capacity and as personal representative of the estate, and in her capacity as trustee of the living trust. BTJD is in receipt of the SDT dated June 23rd, 2025. Sorry, I was reading the chat on a hot summer night. He wrote Billy Bob loves Charlene. And John Deere Green. With letters 3 foot high. You guys are, I'm living. Thank you, everybody, for being on the same page. I appreciate it. Continuing on from the John Deere Green. The subpoena asks for 17 discrete categories of information pursuant to Rule 14C, Utah rules, other rules. As a threshold matter, the subpoena appears to seek duplicative discovery or materials that are already in Kouri's possession. For example, request number 5 asks for documents, quote, showing the financial activities of the trust from March 3rd, 2022 to present. Katie previously produced to Kouri through her civil counsel accountings for the trust. And Kouri's civil counsel represented to Judge M in March 2025 that he intended to share those accountings with Kouri's criminal counsel. The accountings are, by court order, AEO, protected and may not be disclosed to Kouri. Given those representations, we see no need for Katie to reproduce the accounting information. In addition, request number 3 is duplicative of other discovery that Kouri has or should have. Our understanding is that Todd, I think it says Gabler, but I can't tell in which order the L and the R go. So Todd G is what we're going with. Already responded to a subpoena from the state and, in so doing, produced his entire investigation file. Katie is not obligated to reproduce that from which Todd G already turned over. With respect to request number 8, we understand that the state of Utah has procured and produced the OME's entire file concerning Eric Richins, including all of the OME's communication, the coroner's office, the medical examiner's office. What the fuck are they asking for in number 8? Hold on. Why are you asking the executor of the state for the OME file? Number 8, any and all emails, text, audio recordings, checks in payment to, or personal communications between you and any employees of the Utah Medical Examiner's Office, including but not limited to, and then names employees. Okay. I'm sure there are communications wherein they said, I don't know, we can release his remains. I mean, they have the OME's file. What other information do they need? They would have released him at some point to his family. What? They say if the state has already produced documents or correspondence and discovery, Kouri has no proportional basis to seek the same documents from yet another source. Second, each of the subpoena's requests are vague and ambiguous. Depending on the true nature and scope of the subpoena, it potentially subjects Katie to undue burden or cost. Specifically, most of the requests are not limited by subject matter or time. Request number 1, for example, request all emails, letters, text messages, personal or professional correspondence between Katie and 5 categories of individuals over a 3-year period. It's possible that Katie has communicated with those individuals regarding subjects that have nothing to do with Kouri Richins or the state's charges against her. Request number 2 seeks any written or recorded statements that Kouri made over a 5-year period. As written, that would include a broad and unwieldy universe of documents. There's a period there. Broad and unwieldy universe of documents. Even something as innocuous and irrelevant as a Christmas card would technically be responsive. There is no legitimate justification to subject Katie to the burden of scouring for every single quote-unquote writing Kouri has shared with her over the past 5 years. Request numbers 3, 4, 5, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17 have similar subject matter and time problems, and each subjects Katie to an undue burden. Third, no and 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 no. Just Be Nice said, wait, what Christmas cards? This is between the defendant and her sister-in-law. So one could imagine that there were Christmas cards and birthday cards. It says all writings between Katie and Kouri. So if Kouri sends a Christmas card to the family, could that technically be a writing? Yeah. Third, the subpoena requests information not in Katie's possession, which again imposes undue burden on Katie and serves no other purpose than harassment. Request number 3, for example, requests recordings made by Todd G. and, quote, any other individual. For one thing, if Kouri would like recordings that Todd G. made, she can send, and has in fact already sent, a subpoena to them. For another thing, counsel's getting into it now. Counsel's like, and for another matter, for another thing, Katie has no way to identify which, quote, other individual Kouri has in mind. Even if she could, it's unreasonable to ask Katie to track down that unidentified individual, procure their surveillance footage, and then produce it. Requests 4, 9, 10, 11, 12, 13, 14, 15, 16, and 17 suffer from similar problems. Doctor Who said, is this the Sesame Street motion? Number 1. Yes. Mr. Bloodworth has now become the Count. Fourth. No. But in more words, the subpoena improperly requests privileged information. Code section. Todd G. is Katie's retained expert and legal professional representative. What? That's not good. Todd G. is Katie's retained expert and a legal professional's representative, and he has been so for multiple years. Her communications with him are privileged. Wouldn't they have known that? Liz Rose in the chat said, oh, wow, my Lawnard merch has been delivered during the live. Love it. Megan said, Emily's voice put me to sleep again accidentally. This happened to me this weekend. I was cuddled up on the fall nights out on my, it's basically the catio, but out on the porch in my Lola blanket and was trying to read and completely fell asleep. I was just too cuddled up. I was too cozy. The air was cold, but I was warm. It was delightful. So cozy. And then immediately asleep. I was like, well, I was going to read. Guess not. They go on to say the same applies to Brooke Carrington and Matthew Throckmorton? Matthew Thunderstruck. I am sorry, but I think that says Throckmorton. I'm kind of envious of this last name also, but Throckmorton? I am sorry, Matthew Thunderstruck. But they are saying that Brooke Carrington and Matthew Throckmorton are also privileged communication. Carrington is Katie's former expert, and Throckmorton is a current expert. The forensic accountants. Because Carrington testified at the bond hearing about the accountings. Teresa said, so the Lola blanket is really nice and not hype. I will tell you my beef with the Lola blanket. Here is the problem. Everyone in my house keeps stealing it. So both of my kids have raised beds, one higher than the other. So I have to go climb a ladder to try to find my blanket and recover it for myself. And invariably, when T leaves it in his bed, because he steals it, when T leaves it in his bed, the cats are both on it. And then they look at me like I am the meanest human in the world for trying to take my blanket back because they are cuddled up on it in Travis's bed. And they look at me with the sad faces and go, why are you taking our blanket? Why do you hate us? Why do you not want us to be comfortable? You climbed all the way up this ladder, and now you are stealing our joy. Evil, mean human. And so then I have to go find the other one, which invariably Griffin has. And then Griffin comes home and is like, who moved the blanket? I'm sorry, my blanket? I just wanted to sit outside and read. So our problem is that we do not have enough of them. And that is an ongoing issue that will probably be reserved over the holidays. Not the cat saying, how could you? 100%. You know, they both cuddle up in it together. And then I go up to grab it and they both go at the same time, both of their heads just stare at me. How dare you touch this? Lola does sponsor me. I'm waiting for our next code to buy more. No, 100%. We need more because they have been stolen by everyone. So that is the thing. So don't worry. I will be buying more for the family. Do not send them. Buy them for your families. We will have a code coming up shortly. We have one on a podcast episode. We'll find it and put it down in the description if you need the code, because get your discount. I think it's still active. If not, wait for the next one, which will be soon. Subtracted by Mr. Throckmorton. It's just such a great last name. All right. So Matthew Thunderstruck and Brooke are the experts. They're privileged. The lawyer for the trust goes on to say Christine Miller and Crystal Bowman Carter both represented Eric prior to his death. After he died, Eric's attorney-client privilege passed to Katie in her capacity as the estate's personal representative. Katie will not divulge Eric's privileged communication. Neither will she divulge communications she has had with Miller or Bowman Carter in her capacity as personal representatives. Moreover, after Eric died, Bowman Carter represented Katie in the Utah District case. Katie's communications with Bowman concerning those matters are privileged, and Katie will not produce them. Finally, Katie's communications with Greg Scortis, if there are any, are privileged. Fifth, although Katie is not party to the criminal case, not lawsuit. Since Katie is not a party to the criminal case, it seems fairly obvious. Oh dear. Counsel says it seems fairly obvious that the subpoena seeks irrelevant information. For instance, Katie's communication with her or Eric's various lawyers have no bearing on whether Kouri murdered or attempted to murder Eric, and neither do Katie's communications with Cody Wright. From what appears, the subpoena is little more than a blind fishing expedition through which Kouri aims to harass Katie and needlessly drive up legal fees. Shocking allegations, I tell you. Shocking. 6, unless and until Kouri is acquitted, she is not a qualified beneficiary of the trust and has no right to see trust financials. In addition, Eric's trust agreement expressly permits Katie in her sole discretion to furnish the beneficiaries with limited or no information concerning the trust finances, beneficiaries being the kids. Look, from all accounts in the filings that we have seen, Kouri had no idea that Eric had changed his estate planning and found out after he was deceased and lost her ever-loving mind. She didn't know about this before the murder. So she does not have any room to argue relevance to any of this because she didn't know. She just had no idea that any of this had happened. So how can any of it be relevant? It doesn't go to negate anything in this case because her state of mind was ignorance of all of this. That was her state of mind. Oh, footnote 2. Katie acknowledges that Judge M interpreted Utah Code Section 75B 811.3 as a mandatory rather than default provision, hence the reason why Katie has furnished Kouri's civil counsel with annual accountings, subject, of course, to Judge M's limitation that Kouri may not see any of the accountings prior to her criminal murder trial. Because she intends to seek reconsideration and or appeal Judge M's decision, Katie lodges this objection purely for preservation purposes. There is more going on in the civil cases, or there was. The civil cases are now stayed. But there was more going on in the civil cases, and the civil cases caused a conflict, and that conflict that conflict was the reason the court stated on the record that Kouri's last set of attorneys were removed or left the case. Sorry, my throat just went. So there is a lot going on the civil side, but whatever was going on the civil side created a conflict where the attorneys left. So continuing on, the attorney for the estate and for Katie asked the court to deny all of this and says she doesn't get any of this. Or no, they don't ask the court. They tell the attorneys, we're not giving you this. And then they said, subject to and without waiving the foregoing objections, Katie produces with this objection, the materials in her possession that she believes are non-privileged, proportional, potentially relevant, non-duplicative, and discoverable. And then the attorney with the greatest signature I have seen in quite a while signed this. It's a great signature. It's a great professional signature. I dig it. And then, because the defense is asking for a hearing on this, other than just sending the letter, Katie's attorney responded. And Katie's attorney is not happy at all. And this is the second time we have seen a request for sanctions in this case, because we have seen another attorney move to quash a subpoena and ask for sanctions, or an attorney in their other capacity. So Katie's lawyers responded. I am telling you now, we are not going through all of this. We are going to go through a lot of this. So grab a snack. This was signed on October 23rd. You will see when I pull this up that this is 217 pages. We are not going through all 217. A lot of that is attachments that are parts of the trust documents. But we are not going to go through all of it. We are going to go through some of it. But they are asking for sanctions. And I am curious about what they have to say. So this is the response from BTJD regarding the SDT of defendant Kouri's SDT with regard to Katie and Katie's documents. So first, the statement of preferred disposition. The motion intimates that there is some level of mystery or intrigue surrounding which individuals that Katie as trustee and PR has used as expert witnesses in her litigation against Kouri. Remember, There is civil litigation that is currently stayed regarding the estate. I've covered that in other content. The stay is pending the outcome of the criminal trial because it will change the disposition. If Kouri is convicted of murdering Eric, they are not going to continue to argue over whether she could be a beneficiary or whether or not. I'm going to try to simplify this real quick. If she is convicted, it will nullify a lot of the arguments because she will not be able to benefit from the estate. One of the arguments being made with regard to the pour-over trust is that Kouri was entitled to half of Eric's possessions when he died. So she gets half, the other half goes into the trust. So it's arguing over what goes into the trust, what is included and excluded from the premarital agreement, sometimes called the PMA. However, if she is convicted, then it does not matter. The pour-over trust essentially means that after the death, everything just, it spills over into the trust. It's just go there. So there's no need to go through probate or whatever. It all just, what you had goes into the trust. And then the trust handles all of it and the executor handles all of it. So I think it's a pour-over living trust, but also Utah. Give me two. So that is the argument. The argument is over what goes into the trust. Kouri's saying, I'm entitled to half before it goes into the trust. And now it's stayed because if she's convicted of killing him, she doesn't get it. And then everything goes into the trust. So instead of like, I get half the house, I get half the business, like half of his half, etc. So that's being fought over. Excuse me. That's being fought over separately in civil. And it will be dealt with after the criminal trial. It is now currently stayed. But that's why we hear conversation regarding some of these documents from other things. The defense, the estate attorney is clarifying now what the defense was insinuating. The defense was insinuating that Katie was like paying witnesses. The estate's attorney is saying these are her expert witnesses in the civil case regarding the estate. Like you need a forensic accountant. So these are expert witnesses. So to highlight that fact, they said, the motion intimates that there is some level of mystery or intrigue. Ooh, we love a good intrigue. Isn't that why we're here? Surrounding which individuals Katie has used as an expert witness. Oh, I forgot that this light down here was on and it reflects in my glasses. That light is new. Turn it off. That one. The attorney for Katie goes on to say, there is no intrigue. There is no mystery. If Katie's relationship with Todd G and Carrington and Throckmorton, or Thunderstruck, are quote unquote secrets, they are some of the worst kept secrets in the world. It is a well-known and undisputed fact that Todd G is Katie's retained expert. Kouri has known this because Katie transparently broadcast it to her for over 3 years. Carrington readily testified at Kouri's preliminary hearing, and Katie had previously paid her for expert accounting work. And Katie told Kouri in objecting to her subpoena that Throckmorton is a retained expert. Kouri does not need anything more to prove these facts. Yet without evidence or legal basis, Kouri believes that not only do these facts make those three individuals non-credible witnesses, but also that they give Kouri unfettered ability to pry into the trust in Katie's confidential finances. She is mistaken. Suspected quote-unquote bias is not a free pass to seize sensitive information. Neither does it excuse litigants from standard discovery constraints, things such as relevance, proportionality. Katie has produced to Kouri's criminal counsel all documents that are non-objectionable and discoverable. Kouri cannot have anything else. I mean, period. Period. Kouri cannot have anything else. No more documents for you, Kouri. None for you. None for you. None for you. No more for you. Get out. Stop it. No more documents. The trust has their own experts. At the bail hearing, we heard from Carrington, who said that she was digging into all of these areas because she was trying to figure out A, the trust, and B, where the money was going. But the Kouri cannot have anything else is so funny. It's so direct. I just love it. No. Look at how much more fun direct language is. No need for quotes. The facts are Kouri cannot have anything else. They go on to say the court should deny the motion for several reasons. First, both the Utah Trust Code and Eric's trust agreement preclude Kouri from obtaining the documents she seeks. No. Second, the motion's only substantive justification, alleged biases of 3 witnesses, lacks merit. Well, the defense knows. Samantha in the chat said, it's giving and none for Gretchen Wieners. The defense knows who they are. If they are called as witnesses, the defense can say, were you hired by the trust? Yes. Were you paid by the trust? Yes. Because they know that that's true. They don't need the trust documents for that. It goes on to say that the code prevents Kouri from getting the documents, that the grounds of bias lack merit, that Kouri's document requests, not to mention her entire subpoena, are overbroad, that Kouri seeks to obtain privileged information, that Kouri's request for checks connected to any quote-unquote investigation into Kouri is vague and ambiguous, that the motion is procedurally improper, and for these reasons, Katie respectfully requests that the court deny the motion. Relevant facts. In or about October 22nd, decedent Eric Richins created the trust by executing the Eric Richins Living Trust Agreement dated November 3rd, 2020. So he made this initial agreement in November and then executed it in October 2022. The trust agreement instructs the trustee upon Eric's death to divide the trust into 2 separate trusts. The first trust, titled the QTIP, Q-tip. Wait, what? The Q-tip trust is to hold only the marital share. Kouri is the only named beneficiary of the Q-tip trust. The second trust is entitled the Decedent's Trust, is to hold and administer every trust asset besides those in the Q-tip trust. Eric's children are the only beneficiary of the decedent's trust. The trust agreement contains 2 provisions concerning the trustee's obligation to account and report. The first at section 13.14 entitled Trust Accounting states in pertinent part, after my death, the trustee must provide an annual accounting to the qualified beneficiaries of any trust created under this trust unless waived by the qualified beneficiaries. The annual accounting must include the receipts, expenditures, and distributions of income and principal and the assets on hand for any accounting period. A copy of the federal fiduciary tax return filed for the trust during the accounting will satisfy the reporting requirement. In all events, the beneficiary's legal representative may receive any notices and take any action on behalf of the beneficiary as to the accounting. If any beneficiary's legal representative fails to object to any accounting in writing within 60 days after my trust provides the accounting, the beneficiary's legal representative will be considered to assent to the accounting. The trust, look, wills and trust is such a specific area of law. It's so specific. Oh, man. Lexi T said, I did estates and trust law for 17 years. The kinds of trusts out there are mind-blowing. There are lots of things. Lots of things. And they were, it seems to me, based on everything we've seen, that Eric started to see that Kouri was making some money moves that raised an eyebrow, and that he was contemplating divorce, and trying to protect the kids and his assets. So for, wait, where did it go? Somebody in there gave us the full spelling out of the trust. Charlene, thank you, said qualified terminable interest property trust, which Kouri is not entitled to if she is convicted. They go on to line out different obligations of the trust and the trust sections and the reporting. I am not going to go through all the reporting. We have gone through some of it in the past. Again, they are objecting to the overbroad subpoena in the criminal case. Kouri did not know these things existed. So a lot of it is not relevant. They talk about Katie's reporting and what Katie has reported and was obligated to report. In that, the motion says on April 2nd, 2024, Katie produced to Kouri's civil counsel copies of the 2023 reports. Footnote 2, that Katie had previously produced to another individual, counsel for Eric and Kouri's minor children. So there is a guardian ad litem attorney for the minor children. There are 2 minor children, I believe, of Kouri and Eric. On April 17th, 2025, Katie produced to Kouri's civil counsel a general ledger reflecting all trust transactions for the year of 2023, attached as Exhibit 3, which is why this is like 217 pages. On June 26, 2025, Katie produced to Kouri's civil counsel a report on the trust finances and activities for the year 2024. That report is included with a balance sheet and a detailed general ledger. See attachment 4. Footnote 2 says that Katie did not reproduce her reports here. This is for 2 reasons. First, the court previously ruled Katie's reports are AEO, and Katie consequently designated them as AEO protected, so they are not going to be attached. Second, Katie has already furnished the reports to Kouri, to her counsel personally, and to the court. Everybody has them. Everybody has it. The motion. On July 3rd, 2025, Kouri's civil counsel demanded that Katie produce multiple categories of additional information, including but not limited to copies of Katie's 2024 attorney's bills for each civil case between Katie and Kouri. There are numerous. They are all stayed at the moment. 2, a variety of documents pertaining to Katie's wrongful death and financial fraud investigations. Because Utah Code 75B-2-811 sub 3 does not require production of that information, Katie declined Kouri's request. Yeah, none for you. Around the same time, Kouri sent a subpoena to Katie out of this case. Isn't that interesting? There are numerous civil lawsuits with the trust, and then Katie suing the trust. No, Kouri suing the trust, Katie suing Kouri, and other investigations. And the attorney's like, we're not obligated to produce them, so we're not producing them. No. And then after it got shut down in the civil case, then there's a request in this case. Strange. This goes on to detail that the subpoena requested a huge amount of documents and communications, including but not limited to, and we just read those in the last letter, all communications with a variety of people. It's attached as Exhibit 5. It was attached in the last letter that we read from the attorney. Katie timely objected to the subpoena, arguing that Kouri's demands were vague, ambiguous, duplicative, overbroad, burdensome, irrelevant, and exceeded the types of documents that Kouri could receive as an alleged beneficiary, and sought privileged information. And then Katie also produced some things to Kouri. We just read about that in the other letter. Roughly 2 months later, in the reporting case, Kouri filed a motion to require production of trust report information and enforce a May 14th, 2025 order requiring trust accounting. Despite sitting on Katie's reports for close to 3 months, from June 26th to September 25th, Kouri is now acting as though it is an emergency that the court hear and decide the reporting motion within the next 60 days. The supposed emergency in the reporting case has nothing to do with Kouri's asserted beneficial interest in the trust.
Rather, she seeks an expedited ruling due to the limited time available to obtain a ruling and compliance with any ruling the court may issue prior to the criminal trial. So there is stuff going on in the civil cases and this cases, and she is trying to get to that information any way it seems that she can get it. That is what they are intimating in their argument. So there is stuff going on in the case that has stayed. They go on to say that Katie opposed the reporting motion on October 16th, 2025. Right after filing the reporting motion, Kouri filed the motion here. Although it only seeks to compel production of 2 of the subpoena's voluminous records, the motion here demands far more than an annual accounting. Kouri made no effort to meet and confer with Katie prior to the filing. Other pertinent facts. Kouri has known that Todd G is Katie's expert witness for approximately 3 years. And then they cited receipts, screenshots, timelines, fucking everything. Katie previously paid Brooke Carrington to perform some expert accounting work for purposes of her civil lawsuits against Kouri. Footnote 3. This is undisputed and readily evident from 1, Carrington's preliminary hearing testimony, and 2, the reports Katie previously provided to Kouri. She testified at the prelim as a forensic accountant. It goes on to say when the state of Utah retained Carrington to serve as a testifying expert in this case, Katie retained a new forensic accountant for her civil lawsuits. In approximately January 2023, Katie retained Throckmorton, Thunderstruck, as an expert witness for purposes of her civil litigation against Kouri. Footnote 4. And this is the same footnote we previously saw with more cases. Although the court previously ruled in the reporting case that Kouri may receive reports under Utah Code 75B-everything until such time she is determined not to be a beneficiary, either as a matter of law or as a matter of fact, for preservation purposes, Katie does not concede the point and then cites why. It goes on in the footnote to say she maintains, as before, that there is an open question as to whether Kouri is a qualified beneficiary of the Q-tip trust because it remains unclear whether she committed a disqualifying homicide. If Kouri's convicted of committing the homicide, she is not a qualified beneficiary. The law is like, no, you don't get to do that. And then they cite all of the cases involved here and the different places where that's mentioned. It goes on to say, furthermore, Katie maintains her objection to providing any reporting to Kouri with regard to the descendants' trust of which Kouri is not a beneficiary, the kids' trust, or the trust where the kids are a beneficiary. Counsel goes on to say, in argument, from the looks of things, Kouri is trying to use the subpoena as a mechanism to end run the trust agreement and the Utah Trust Code. She cannot lawfully do so. Before getting to that, however, as a threshold matter, the subpoena seeks duplicative discovery of materials that are already in Kouri's possession. Specifically, Katie produced to Kouri's civil counsel, and only Kouri's civil counsel, annual reports for the trust. And it appears that Kouri's civil counsel shared those reports with her criminal counsel. Those reports fully comply with Utah Code section cited, meaning that Kouri has received the full complement of financial information to which this court in the reporting case determined Kouri is entitled. Katie should not have to produce those reports again because she has already produced them once. And for the reasons that follow, Kouri cannot, through subpoena or otherwise, have any additional trust information. Consequently, under Rule 14 of the Utah rules. It's so fun seeing you guys get your merch today while we're live. I love it. Of the Utah rules, she is not required to turn them over. They also go on to say that the requests are unreasonable. Kouri's record access rights are the subject of civil litigation. As the court is aware, Kouri filed the reporting motion in the reporting case shortly before filing the motion. No matter which way the court goes on the reporting motion, and yes, it is the same judge hearing the civil stuff, it will almost certainly affect Kouri's request here. For example, if the court concludes that Kouri can in fact obtain the information she seeks under the Utah Code, then Katie will have to produce a large volume of information, including most, if not all, of the information Kouri seeks through this motion. Conversely, if the court determines that the trust agreement controls such that Kouri is entitled to nothing other than what the code orders in a report, Kouri will get nothing more than what she's already received. The motion offers no authority or explanation for how Kouri could use the subpoena here to end run the limitations of the trust agreement. Thus, it is wasteful and improper for Kouri to subject Katie to litigation on two fronts with the same issue. The court will decide the reporting case whether Kouri can have the information, and that decision should largely moot the motion here. Footnote 5. Katie has briefed the issue in the other case. She incorporates by reference the arguments she made in that case. Katie previously provided Kouri with sufficient trust reports, and they say, under the law, we have provided her what she is entitled to. She doesn't get anything else. She's asking for more. She can't have it. They're saying that the trust agreement precludes Kouri from getting anything additional, and that was intentional, and that was set up that way by Eric. They go on to say that you cannot use this subpoena to get around the request in the other case. Let's see. They are still arguing about how much information, I am zooming through it, how much information is required. This is expanding on the arguments made in the letter we just read. They say the subpoena is overbroad. It asks for literally fucking everything. You can't have literally fucking everything. The next section is that it's privileged information. You can't have privileged information. No. Vague and ambiguous. Same arguments we saw in the letter. Motion is procedurally improper. Rule 14C of the Utah Rules of Criminal Procedure state the provision of Rule 45 Utah Rules of Civil Procedure will govern the content, issuance, objections to, and service of subpoenas to the extent these provisions are consistent with the rules of criminal procedure. Rule 45 in turn states that if the recipient of a subpoena objects, the party or attorney responsible for the issuing subpoena is not entitled to compliance, but may request an order to compel. To request an order to compel compliance, a party must file a statement of discovery issues, complete with a certification that before filing, the requesting party has in good faith conferred or attempted to confer with the other affected parties in person or by telephone to resolve the dispute without court action. You must meet and confer. You objected. How can we get around the objections? What will you do? What can we do? The objection goes on, or the motion objecting goes on to say, Kouri made no effort to comply with Rule 37. She did not so much, and by Kouri, at this point, they mean her lawyers. She did not so much as contact Katie's counsel about the objection. She did not try to resolve the dispute without judicial intervention, and she did not file papers that conform to Rule 37. Although Katie maintains, for the reasons she articulated above, that Kouri's position has no merit, the court can deny the motion based solely on the failure to comply with Rule 14 and Civil Rules 37 and 45. The court should award Katie fees that she incurred in opposing the motion. Under the circumstances, the rules both mandate and permit the court to impose sanctions against Kouri. Rule 45E1 requires a party who issues a subpoena to, quote, take reasonable steps to avoid imposing an undue burden or expense on the person subject to the subpoena. Where a party breaches that duty, the district court shall levy an appropriate sanction, which may include, but is not limited to, lost earnings and reasonable attorney's fees. Similarly, Rule 37, the rule under which Kouri should have but failed to seek relief, gives district courts discretion to award reasonable cost, expenses, and attorney's fees. Sanctions in the form of Katie's attorney's fees are mandatory and warranted here. For starters, the subpoena itself made no attempt to avoid imposing undue burden or expense. It was a carpet bomb. That's literally what is text. That's literally the text. No exposition from me. It was a carpet bomb. Kouri demanded all of Katie's communications, regardless of subject matter, with numerous individuals over a 3-year period. She asked for every written or recorded statement from Kouri going back more than 5 years. By its plain language, the request would have included a host of innocuous things, Christmas cards, such as Christmas cards, texts wishing Katie a happy birthday, or random and immaterial voicemails. It goes on to say, and Kouri did not stop there. Oh, no, she didn't. Oh, no, she didn't. And Kouri did not stop there, although she should have known they were privileged. Kouri demanded all of Katie's communications with individuals like Todd G., Carrington, Throckmorton. No, damn it. Thunderstruck. No, Throckmorton. And the attorney Bowman Carter, the attorney Miller, and attorney Skordas. She made sweeping, nearly unilateral requests, such as any and all correspondence. Put another way, oh, please do. Put another way, she plainly asked for every email, letter, text, agreement, and payment between Dr. Gray and any other person for Dr. Gray's entire life. There were multiple similar requests. And of course, Kouri also demanded all documents showing the financial activities of the trust from March 3rd, 2022 to present. Nothing in the subpoena indicates even the slightest measure of restraint, proportionality, or effort to impose an undue burden. Yeah, the subpoena was written like a criminal request for discovery, not a civil subpoena. And the civil attorneys are saying, no, you can't just request all. It's not the crime lab. They go on to say, to make matters worse, the motion, which Kouri limited to request number 5 and 6 in the subpoena, exemplifies Kouri's lack of restraint. I mean, is that the only thing? For one thing, Kouri is already fighting for additional trust information in the reporting case, footnote 13. Not for nothing. Really? That's how we're starting the footnote? I like it better than at bottom. Not for nothing. Kouri's request in the reporting case is a violation of the court-imposed stay. I thought there was a stay. Why are they requesting things? I was so confused. I'm really glad there's a footnote because I was like, did the court lift the stay? Was the stay was there an asterisk? But thank you, counsel, for clearing it up. Not for nothing. Kouri's requests in the reporting case is a violation of the stay. That makes sense. Where was I? Oh, to make matters worse, the motion, which Kouri limited to request number 5 and 6 in the subpoena, exemplifies Kouri's lack of restraint. For one thing, Kouri is already fighting for additional trust information in the reporting case in violation of the stay. She has unabashedly indicated that her fight there is purely about the criminal lawsuit. See request for hearing, Exhibit 12. Chat, make a note. We got to go to Exhibit 12. I wasn't going to look at all the exhibits, but we got to look at Exhibit... Hold on. We got to look at 12. Because I'm real curious. She knows that her civil counsel is sharing documents with her criminal counsel. There was no economy or restraint in Kouri's decision to try to fight this out on two fronts. Well, she's got nothing to lose. She's in jail. She doesn't give a fuck. Her lawyer should. She doesn't. For another thing, counsel's like, but wait, there's more. For another thing, the motion bizarrely faults Katie. Counsel's like, I'm just getting warmed up. The motion bizarrely faults Katie for failing to produce documents that show, quote, whether there are other witnesses in this case who have been paid by the trust. Which witnesses does Kouri have in mind? And for another thing, the individuals named in the subpoena or other unnamed individuals. Katie is not a party here. She does not know who precisely is going to testify. If Kouri has or had specific witnesses in mind, it was incumbent on her to ask for payment information concerning those witnesses. Or at a minimum, she should have provided a fulsome list of potential witnesses about whom she would No, she wanted to inquire, footnote 14. That is one of the many things Kouri could have done to avoid imposing an undue burden on Katie. Instead, Kouri foisted the largest burden imaginable on Katie, compiling and producing every document in existence that has anything to do with the trust's financials. Footnote 14. For the avoidance of doubt, Katie does not mean to imply, state, or concede that she has retained anyone other than Todd G., Carrington, Throckmorton as expert witnesses for her civil lawsuits. Like, who do you think? And also, this is it. The craft witch Rachel said, E2B, this is attorney DJ Khaled. Another one. I'm not done yet. Perhaps, it goes on to say, Kouri could have limited the subpoena's scope, thereby decreasing Katie's burden. Look, we read the communications where Kouri was talking about how much better she is than Katie, and how if they want to go after Katie, they need to leak photos of Katie's children to the media. Yes, that was in the communications. I had forgotten about it. And then when we went through the walk the dog letter again, I was like, are you fucking joking? I had forgotten how mad I was about that. I'm mad about that still. Oh, I know how we can get her. It's leak photos of her children to the media. It's your nieces and nephews, Kouri. Seriously? It's the, oh, but I would never. Oh, okay, but what's in your letters? It's giving Donna, Kouri. I would never do that. Your emails say something different, Donna. And Kouri, your jail letters and phone calls say something different. Perhaps Kouri should have limited the scope. It goes on to say, or perhaps during the same call, the one she never made, during the meet and confer call, she should have gotten informal answers regarding who Katie has and has not retained as an expert witness. Your Honor, we wouldn't even be wasting your time if they had met their simple obligation of a meet and confer. Jennifer in the chat said, no, she didn't. She did. Among other things. She talked about how jealous her sister-in-law was of her. It was on and on and on from Kouri of she's mad because I'm better at her than everything. Perhaps Kouri should have just called us up and had that meet and confer that the law requires. Your Honor, we wouldn't be wasting your time. It goes on to say neither Katie nor the court will ever know whether judicial intervention could have been avoided because Kouri made no effort to confer. Your Honor, I'm so sorry that we are burdened in wasting your time, Your Honor. We could never know what could have been if only they had had a meet and confer call. We'll never know. And now you have 217 pages of motion. Enjoy. I'm sure the court's calendar is not busy. They go on to say, after Kouri made no effort to confer, in violation of Rule 37, she rushed straight into filing this motions. Sanctions are appropriate because Kouri sucks. No, that's not what it says. Sanctions are appropriate because Kouri has overstepped at every turn. The subpoena is terribly overbroad and requests information to which Kouri plainly has no right. The motion is duplicative of Kouri's civil efforts to obtain documents, and Kouri violated Rule 37. And under Rule 37 and 45, the court should award Katie fees. Your Honor, pay us. Because damn it. Conclusion. The plain language shade does not stop. Kouri cannot have anything more than what Katie has already produced. It's the lawyer version of you get what you get and you don't get upset. Katie respectfully requests the court deny the motion and award attorney's fees. Denied. Give me fees. Give me money. Look, ultimately, here's the thing. All the attorney fees they're running up comes out of the trust. Who is the beneficiary of the trust? Kouri's children. Kouri's children are the beneficiaries of the trust. Because I don't foresee a world in which Kouri becomes a qualified beneficiary of this trust. I do not see that happening. I mean, that could change, but at this moment in time, I do not see that happening. Exhibit 12. Lawners 100, It'd Be Fluffy, 1010. 1010. We're going to zoom through the, no, I'm not going to make you do that on screen. I'm not going to make you do that on screen. Hold on. Let me try to zoom past the trust agreement. As I said, there are over 217 pages of attachments. Some of this is going to be trust agreement, which is on my second screen. And it is numerous trust. Exhibit. I'm only at exhibit 2. This is page 116 and we're only on exhibit 2. Oh, they're emails. Hold on. I love a civil lawyer, you suck email. Look, I hate writing them. I don't want to have to read them. I don't want to be the research attorney dealing with them, but do I want to read them with y'all? Yeah. Yeah, I do. Yeah, I do. We got a minute. Exhibit 2, April 2nd, 2025. Emails. Randall. Attached are the 2 reports that we sent to Attorney Chandler. A reminder that the court ordered these to be treated as AEO. Attorney's eyes only. Perfect. Okay. Exhibit 3. More emails. 4/17/2025. Emails with attachments. Randall. Attached to the general ledger. Look, they said we turned these over, and they're saying, look, we turned these over. Exhibit 4. 6/26/25. Email. Deborah and Randall. Attached to the financial reports for the Descendants Trust, the Kids Trust. A reminder. The court ordered these to be AEO. Exhibit 5. Subpoena. We've already gone through it. Overbroad. You asked for too much. You get nothing. Which we boot scooted back and looked at that in the original motion. Exhibit 6, objection to subpoena. We read this entire letter already. Get nothing. Great signature. EDB's summary. Get wrecked. Signature. Exhibit 7, a different subpoena. To Rudiger investigations. Okay, give us your stuff. Sure. No. Continuing. What the fuck is up with this subpoena? That's not me. What happened? For those of you listening in the background, you just have to look. I don't even know. I don't even know. It's not you. I was trying to scoot through this and I was like, what is happening? Some kind of formatting went wild. The subpoena Deuces Tucum is just missing like every other letter. It's a freaking nightmare to look at. If you really want to just mess with yourself, this is wild. I don't know what happened to the printer, but it looks crazy to look at. There's just like letters missing everywhere. It is a mess. I don't know how that even happens, but yikes. So that subpoena was included. There's another objection to that subpoena and exhibits to the objection to that subpoena. Your Honor, we can't read it. Statement of discovery issues in the civil case. We're not going through that. The court's already dealing with that. All right, we're at page 169. We're at exhibit 1 of exhibit. I don't even remember which exhibit we're on. Exhibit 1 of that exhibit. And then exhibit A, B, C, D, E, F, G of that exhibit. Exhibit 10. Ooh, we're almost there. Objections to SODI, SODI. Also printed strangely, this is all in the civil case. Same heading issues. We're almost to 12, y'all. We're almost to 12. Though I'm very interested in what's included. This is Exhibit A of emails. Hold on. Backing up. Boop, 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 boop. My nosy ass wants to look at the emails. This is the objections to the statement of discovery issues from the investigations team. Let's see. This is dated November 4th, 2023. We're just jumping into investigations. We have no idea what's happening. I don't care. We're reading emails. Let's go. Kennedy. On behalf of Rudiger Investigations, I am writing to follow up on our discussion last week. Based on our conversation, we understood you are seeking information regarding certain bank records. Having discussed this issue with our client, we believe any and all questions regarding these records should be directed to counsel for the trustee, Kouri Richins. As you know, the trustee represented by counsel at Bennett Teller, BTJD. Given Rudiger's role in performing work for BT, including work related to the records at issue, we believe you should make any and all demands concerning the records to lawyers, not investigators. Accordingly, I have included in this email the BTJD attorneys representing the trustee. I also note that we have passed on your questions regarding bank accounts to the attorneys. It's my understanding that counsel at BTJD is happy to discuss the matter with you and able to address your questions. So thanks for asking. No. Regards, Jeff. Jeff is like, yeah and no. Kennedy, thanks for checking in. We're still following up on some issues. So these are all the emails like, hey, are you going to give us that stuff? No. Jeff is like, no. We're not. No. So that is them trying to get bank records, more exhibits, and a denial of that request. Exhibit 12. Damn it. It's one page. Emily, we're not going to go through all 217 pages. Here we are. Page 216. Request for a hearing. Filed in the other case. Comes now petitioner Kouri Richins. Remember, this is in the civil cases regarding the estate that are stayed. Petitioner Kouri Richins, through her attorneys, Randall Jeffs and Ryan Morley of the law firm Jeffs & Jeffs, and pursuant to rules, request the court to schedule a hearing in connection with her motion to compel production of trust report information and enforce the May 14th, 2024 order requiring trust accounting. The case is stayed. The reason for filing the request for hearing at this time is due to the limited time available to obtain a ruling in compliance with any ruling the court may issue prior to Kouri's criminal trial. The information sought likely will have direct impact on the evidence to be presented at Kouri's criminal proceeding. They weren't exaggerating that. They said. She said that this is because of the criminal case. They sure did. They sure did. Therefore, it is requested that a hearing for this motion be scheduled within the next 60 days. I really want the judge to just be like, yeah, this case is stayed. Judge M is dealing with the civil cases in addition to the criminal cases. Excuse me, counsel. Stayed means stop. Right there. Thank you very much. Or stop, collaborate, and listen. Or stop in the name of love. Any others that we're missing today? We're probably missing some. We're missing some. Yes, hammer time. Correct, chat. Stop. Hammer time. All of them. So no, it stayed. It stayed. No hearings. Stop. Wait a minute. Yes. So, not just says, is it weird Judge M is handling both? No, it's not weird that he's handling. It's unusual to me because it is an estate. However, it makes so much sense to me that there are overlapping issues here that it, instead of having one court and another court try to go back and forth with what's being handled, it makes so much sense to have one judge be like, no, this is what's happening in the criminal proceeding. This is what's happening in the civil proceeding. This is where there's overlap. Like, this is kind of the epitome of judicial economy. It would not happen in some jurisdictions where probate courts just get their own space, but it makes a lot of sense to have this all handled, especially if the judges handle both criminal and civil. Gen X Meg said, stop, drop, shut them down, open up shop. Oh, yo, I forgot those two words. This is how Rough Riders roll, I think is the next one. Yes. Stop, drop is very good. So, the case is stayed. You don't get to have hearings when the case is stayed. I'm interested to see what Judge M does. They need to have a hearing. They have a motion pending with regard to the walk the dog letter. We have not revisited that in a minute. It's on my docket. There is the motion for bond or the request for a hearing. I don't think the court's going to grant the request for a hearing. There's a request for the discovery. There are numerous issues that still haven't been dealt with. There is nothing as of this morning on docket. It will have to get put on docket at some point. They don't have hearings really scheduled till January because trial is set to start at the beginning of February with jury selection. So there is a lot of hearings that need to happen before jury selection in this case. And I'm curious to see what the court does. I think with the stayed case, the court's going to say, we're stayed, you don't get any. No, we're not deciding this. And in the criminal case, the court's going to say, I imagine these are overbroad subpoenas, but it needs to be heard before the court. And I imagine with regard to the bail bond hearing, that the court's not going to grant a hearing and he's not going to find a change of circumstances. And then he's going to say to the people, I imagine, turn over witness statements, unless that is contrary to what the code says. But the prosecution didn't cite the code. The prosecution said there's nothing exculpatory. I imagine the court will say, can you just give them the witness statement? What are you doing? Give it to them. Stop it. And nothing else. We'll see. The motions are going to start to ramp up in the Richins case. When they get put on calendar, I'll let you know so we can cover them. I'm very interested to see how these go. The court does not allow live streaming. So oftentimes we get them on a delay. Oftentimes I will try to tune in and listen so that if we don't get all of the hearings, I at least have a record of what happened in the hearing by taking notes and listening in on the hearing, because I will remember what I hear more than I will remember what I write. So we will see what happens in the Kouri Richins case. We will be covering it at trial when it goes to trial, unless it gets delayed again, in February. The court took a painstaking amount of time to set forward that hearing. So, with all of that, we're going to answer some questions. And then tomorrow we are going to food court. Bring the snackies. We have lots of food court. And Wolf Kara asked, do we do it the day after? When? It depends on when it gets posted by the pool and when I can get it. Sometimes it's a few days after before there's even any video available, because I am not in Utah with the camera doing it. Tomorrow's food court. For those of you that are new to the channel, you do not want to miss food court. We will talk about some food court cases. And we have to talk about a Canton resident that has been wilding out on the interwebs. So we will talk about that too. You do not want to miss food court. We got big plans for food court. We are ready for food court. Cleopatra asked, did the court allow the trial to be streamed? We don't know yet. I am optimistic that once the jury is selected, the court will allow streaming even if it's on a delay or two. I'm optimistic. So food court tomorrow, we are going to talk about some food-related lawsuits. We have some true crimey stuff we need to talk about, which we don't normally do, but for food court, we're going to. There's drama. We're going to talk about it. I have a little bit of beef. We're going to talk about that too. The members know some of my drama. We're going to talk about it for food court. Also on Thursday, today's Tuesday, Thursday, we have a hearing in Massachusetts. We will get to that hearing live. It's an afternoon hearing. So if you do not have the Law Nerd app, I was trying to remember all the things I wanted to say. If you do not have the Law Nerd app, now is the time so that you do not miss out on all the fun things. Also, food court tomorrow is going to start a little bit later. I am doing a quick podcast interview regarding some other legal stuff. I'll let you know when that is live, but I'm doing a quick interview. So we're going to start at 11:30 tomorrow. Get prepared. Just get prepared for all the things. And then on Thursday, we will be going to Massachusetts again. And in Massachusetts, we will be covering all of the drama surrounding trooper proctors, former trooper proctors, proctors' texts, and proctor's log. Privilege log, people. Privilege log. The privilege log. So we will be doing an afternoon hearing on Thursday. And then I will be scooting out for a football game. So Anita said, ADB, what is food court? So when a lot of us were growing up in the US, every mall had a central area with a whole bunch of like mall restaurants. Sapporo Pizza, pretzels, you name it. In California, there was often a hot dog on a stick, some type of noodle, something, sometimes like a Mongolian barbecue. But there was always Orange Julius, Cinnabons. Everyone's thinking of putting in their foods from their food courts. So there was a food court in the middle of the mall, the always centralized. There are autonomous eateries that are not in the middle of the mall, but there is a food court. And what is in the food court and what is not in the food court can be discussed, as it was in the movie Mallrats. What counts as the food court and what doesn't. But food court in the mall is the location that the name has come from. Malls don't always do food courts the same way anymore, but it was also where, as younger teens, you would all just kind of end up at the mall hanging out because mall kids. So when we started covering cases that related to food things, foods, drinks, is the bread from Subway bread or not? We started calling it food court because the food court location of our youth and the fact that we are talking about food-related laws and lawsuits. So food-related laws and lawsuits, not to be, the mid-mall snacking exactly. Sbarro was the closest thing to food court in the food court to Italy. Sbarro definitely is not Italian. Food court is not members only. We do sometimes talk about food court on members only. Tomorrow is not. Tomorrow we will talk about actual food lawsuits. There are actual food lawsuits we need to talk about. And then there is just some hilarious shit we will talk about. So tomorrow will be a lighter episode. We will talk about food related things. Sometimes the food lawsuits were like, shut the fuck up. Sometimes the food lawsuits were like, hey, I'd actually be mad about that. What are you doing? A lot of the food lawsuits that we cover are all filed by one law firm because there is one law firm that is just like, haha, is there real fruit in the Starbucks refreshers? Give us money. But there are some food lawsuits we need to go through. Remember last year we covered whether or not the Reese's pumpkins had faces on them. We have covered whether or not it's false advertising if macaroni and cheese says it's ready in around 2 minutes. If that does not count for the time to pour the water into the mac and cheese to make it mac and cheese, yes, that was a lawsuit. Yes, we covered it. So we will food court tomorrow. We will get snacks. We did talk about the hot sauce. You know, whether it's misleading that Texas Pete's hot sauce is not made in Texas because the plaintiff in California wanted a Louisiana style hot sauce from Texas. They said that in the lawsuit that they would not have bought Texas Pete's if they had known that it was not a Louisiana style hot sauce made in Texas. And it all started really with Colin and Cuthbert. Hence the caterpillar cake. We've also talked about Crumble and Dirty Dough, but if you have not watched Colin and Cuthbert, that was the beginning of food court. And really, the reason that Colin and Cuthbert came to food court is because the social media fight over that lawsuit was hilarious. And if you would like to see me just laugh at the legal drama that is Colin and Cuthbert, well, we will link it down below. It was really what kicked off food court, and it still remains one of the funniest things I have ever seen. It was ridiculous. It is a classic, and the pinging between the two still goes on. The cookie war were not quite as funny. They were pretty funny, but Crumble wasn't really funny. Dirty Dough, I almost said DP Dough, different things. Dirty Dough was pretty funny. We talked about the Olympics. We did. We talked about one of the Paul brothers, whichever one does prime. And then they settled because they were like, yeah, we're not going to win. No, they're not going to win. I'm sure they paid the Olympic committee some amount. Food court. Food court tomorrow will be, well, spicy. Pumpkin spicy. I'm ready. You're ready. Food court will be a whole situation. I will see you tomorrow. Let's answer a few questions real quick, and then we will go. For all of you asking, I did not get a Spidey D Halloween costume. They sold out like immediately. I did not. I do not have one. Just so I do not have one. I apologize. It's not going to happen. Quick questions. Awesome said, is it really mac and cheese if it's just cheese flavored powder? I mean, it came up with some type of cheese stick that was in food court, and it was a different kind of cheese in the cheese stick than was advertised in the cheese stick. I think they were advertised as mozzarella cheese sticks, but the ingredients said they were like cheddar cheese sticks. It was a very weird thing. I was like, what the heck is happening with what the fake mozzarella? We have had some very interesting food court. We have not done a historical food court. We need to go back and talk about some of the more serious food court cases, like the McDonald's coffee case. We need some of those, but we have not done them yet. Tomorrow is not the day. Vesselette said, did I end my team meeting early to be here? No shame. Did end my team meeting early to be here? No shame. I mean, I'm here for it. Team Baker, well, we plan our meetings around streaming. It makes it easy for us, but yes. Good to see you, Alice. In the chat said, happy to be here. Love you. Law Nerds, it's always so good to be here with the Law Nerds. Fluorescent said, I'm ready for the Kouri Richins trial. Me too. I think Kouri will probably testify. Then again, I thought Donna would probably testify, and I think it was better that she didn't, but I think that she will. Hickers73 said, Emily, thank you for all you do. I love listening to you over anything on YouTube. Thank you. We're here. Sometimes we talk about fun things. Sometimes we talk about hard things. Sometimes we make hard things fun. Damn it. We'll talk about those things tomorrow too, I'm sure. I have a food court related item to share with you. Joe Beer said, so glad you had a great time. Happy Halloween week. I am so ready for Halloween week. It was a good time. Team Baker and I got a lot done. We did not get enough sleep, but we got a lot done. Cat P said, love that I get to watch EDB on my birthday. Happy birthday to everyone in the chat having birthday. Happy October birthdays. Mama Deadhead said, what about Jackson's letter to Commissioner Cox? We will talk about Jackson and Cox Thursday. But again, am I surprised that Jackson was like, hey, he knew Dever, and said he didn't in an interview. Yep. Bridget said, my Law & Order has been delivered. Can't wait to see it after work. It's always hard to wait when you know that there's been a delivery. I'm glad. It's so fun to see all of you getting your merch. If you post it on social, just tag me so I can see it. I would love it. I'm Kelly and I Grow It said, go to the Music City drag strip for the Haunted Hayride. It was amazing. I have heard it was amazing. It has been on my list for sure. Kelly said, finally made it live. Took over 3 years. It's not always a convenient time for live. Juniper, I agree. No Christmas music till after Thanksgiving. Yes. I mean, if you want to do it at home, go ahead. I'm not going to, no judgment. But like, let the fall have a moment. Daniel said, last live, I suggested that food court code reds be named Food Fights. The motion was granted. I bragged about it to my 17-year-old daughter, who immediately went up me by saying code bread. I do like Food Fights and code bread. It's a code bread food fight. I think we can do both. I'll make a note. Wait, I am literally making a note or I will forget. Chat won't forget, though. Chat won't forget. I think it is a code bread food fight. And I think it will happen. It always does during food court. There's always some kind of nonsense because it's food court. Also, kids are quick. And I love, the humor of kids. It's just like, wah, wah. Speaking of kids, but not kids, Dr. B came home yesterday and was like, so one of my dental students was telling me all about how they knew about your channel from family friends, and what Dr. B was just grinning from ear to ear. So for all of you in the Dr. B extended dental family, thank you. It's good to see you. I appreciate it. Baby steps 2-2. I think we already talked about whether or not Ryan Hall would talk about SoCal. And again, that case is on my list. Kelly, I'm so glad you got your swag yesterday. I love it. We try to make sure that merch is fantastic for y'all. It takes us time. And we are growing. The more we grow our merch store, we hope the more we will be able to add and to include each launch and make sure that we have stuff that is customized for the Law Nerds from us that you guys love. Part of what takes so long is me touching everything and being like, ew, I don't like the way that feels. No, that takes quite a lot of time, actually, for EDB to literally touch everything. Alice, thank you for the gifted memberships. I appreciate it. Fluffy Buddy said, oh my God, I got my EDB Air jacket. I'm in love between this jacket and new nail polish. Mooncats 404, Soul Not Found. I feel so cool. You're welcome. 404, Soul Not Found is hilarious. Debbie, thank you so much. Happy 50th birthday. I'm excited that you're here too. Lots of birthday Law Nerds in the chat. Sarah New said, I have the patient for Proctor's info. Well, there's a chance he will face his comeuppance. I mean, the universe has definitely said, oh, buddy. Yeah, no, we're not going to make that easy for you. IR Meerkat, I will post in our member spaces. So if people want to share their codes, I will post it there. Absolutely. I meant to do that. I totally forgot to do it. Team Baker got into town and I often awayed for all of the things. Team KK said, my husband and I stopped at Dunkin' and I purchased the little Spidey D plush keychain. It made my day. Our Dunkins didn't get any of them. So now I'm waiting for our Dunkins like 2 weeks from now to be like, oh yeah, we got these. Okay. So lots of you on your birthdays. I love it. Tamara, I think we answered this a little bit earlier. I think it is going to depend. There are possibilities for, I think, Proctor's agency to be sued. And we know Karen Reed is going to sue Proctor. So I imagine it's going to continue to crack open the entire world of all of this because Karen Reed is also going to sue Proctor. So I think we will see it. And I think it will take quite a long time. Rune Munch says, puts a new perspective on the no nudes yet. Karen Reed probably wouldn't have fought if they had kept it at involuntary manslaughter. They wanted that it was second degree, April, but yes, I think they way overcharged that case. But the more we see about it, the more I'm like, what in the world? Kersey Nursey, thank you for the gifted 50 memberships. There are lots of new members in the chat today. We have lots of fun member stuff coming up in the next month. So very exciting. You guys can go back and take a look at some of the old stuff. That's incredibly generous. Thank you for the memberships. You guys are just the best. Richard the Magician, thank you for your very kind super chat. Richard said, I was listening to you, to the Debt Fee Heard playlist. I'm a victim of DV. I wanted to express my appreciation for how you and your community handled it. I felt very seen. Thank you, Richard. You're welcome. The Law Nerd community gets lots and lots of that feedback. It's why we make light where we can, we take serious where we don't, and we look at the facts of the thing because we truly don't know. And every time we look at a new case, we learn how much we don't know. Carrie Bronson in the chat said, are they calling her Katie in the motion? In the motions dealing with Katie and Kouri, it can get confusing between Kouri Richins and Katie Richins-Benson. So yes, in those motions, they say Katie for clarity, but also I shortened her full name to make it easier to keep track. Text Forever said, I call those napsidents. Yes, me this weekend. I love it when it gets cool outside and you can just cuddle up. I love being cozy. Margaret got the EDB air stickers. I love them. I'm glad. I love them too. Alan said, why are civil cases more uncivil than criminal cases? They are. On a side note, my ability to enjoy NCIS trial scenes has been irreparably harmed since I see how many glaring procedural flaws there are. It's true. There are more boundaries in criminal, and you are dealing with different and more constitutional rights, but also criminal law is a smaller world. So when you are working with certain defense attorneys, you are working with them regularly. So burning it all down doesn't really help. In civil cases, a lot of time, these attorneys won't deal with each other that much again. And there is more posturing for your clients that are paying your bills. A lot of the times when you're dealing with a DA and a public defender, the taxpayers are paying their bills. There is no need to prove to their client the same way that they are doing all the things. And a lot of times I think criminal attorneys will look at their clients and be like, if we can all get along, you are going to get a better result. We will fight where we need to fight. We will not fight where we don't need to fight. But I have found civil is definitely, it gets a lot more hyperbolic quicker. Monuments of Speculation, thank you for the gifted memberships. It is much appreciated. And let's see, I've got one or two. Let's see. Joe Jersey said, I miss Colin and Cuthbert. Same. It was very, very fun. It was very fun. I love your Halloween heart in the background. It is very fun. It is two skulls and they sing at each other, but it is so loud. We cannot do it on stream. It will also scare me, but they are two skulls that sing at each other. Tomorrow we will have to remember to, but there are other things that will light up. Spidey is not one of them though. Spidey D will not be lighting up. Maybe next year. Law Nerds, I've missed you. It is great to see you. I will see you tomorrow for Food Court at 11:30. So we're going to be starting a half hour later. It gives you plenty of time to go get your snackies or your pumpkin donut holes. Because Dunkin' really, I love their pumpkin donuts. I do. And I think they discontinue them on Halloween. Also, if it's pumpkin, it should stay through Thanksgiving. Look, peppermint will have its season. Can we let the pumpkin stay to Thanksgiving, please? Who do I need to sue? Maybe that's what we'll decide at Food Court. When are the appropriate dates for pumpkin? Come on. Just through November. There can be a little bit of overlap. We don't have to start peppermint season right yet. Give fall its time. Let pumpkin have its moment. It's my favorite. And then I will be ready to move on to peppermint mocha, whatever. All the Christmassy things. I'm just give Thanksgiving its moment. And then we can peppermint mocha it up in December and January and February if you want. I'm not going to joke about what the flavors of February are. We are going to go. It's not time yet. Do not get rid of the pumpkin. Pumpkin. It's time. I think Jess said, don't forget apple. I think apple gets the whole season, right? You can take apple all the way through December. But just give fall its moment. Law Nerds, I will see you tomorrow. Bring your snacks. Because it's time to have a Halloween food court, and I cannot wait. I'm going to roll the outro. I will see you tomorrow. You're the best. Good to see you, everybody. Take care of yourself. Take care of each other. Law Nerds, cheers. I'll see you tomorrow. Food court. Let's go. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.